Give me coffee in the morning, gotta have the coffee. Wake me up, shake me up, dip me back on pussy. 1 sip, 2 sips, and I'm feeling so alive. Coffee in the morning, it's the best way to survive. Woke up in the morning, sleepy eyes yawning. Jumped out of bed, started the day, opened the curtains. Felt the cool breeze, the sun shining on my face. But something was missing, I needed my job to chase. Give me coffee in the morning, give me coffee in the morning, gotta have the coffee. Wake me up, shake me up, dip me back on pussy. 1 sip, 2 sips, and I'm feeling so alive. Coffee in the morning, it's the best way to survive.
Good morning, good morning, good morning, Carrie. Welcome in. Good to see you this morning. How's everybody doing? Hope y'all had a great night and a good morning. This little bit of a later start this morning was kind of a welcomed thing, I won't lie. So, I hope everybody's ready for this hearing today. Let's get this one over and done with. We can get back to the Karen Reed case. Good morning, Butterfly. Welcome in. I was watching not a little bit, I was watching court this morning, and they have the medical examiner on the stand over in Canton. So, Karen Reed trial, I'm going to have to go back and review that when we're done here. But I did drop the link into our playlist for today's court hearing or trial hearing. I'm getting confused, trial, court, whatever I'm doing here. Good morning, guys. Welcome in. Welcome on in. So I have the link and everything set up and ready to go for when they go live. And it's still going to be a few minutes. I think they got like a countdown going on, like just over 20 minutes before court starts in Idaho. So we'll let everybody get in and gather themselves. I've been up since like 3:30 this morning. Couldn't go back to sleep, so I just stayed up. Already had my coffee and all the things. So thank you, Butterfly. I know you got some things going on this morning, so I appreciate you tuning in and listening. I think we'll have a few listeners today. Miss Dolphin's going to be listening as well. She hasn't left for her trip yet, but she's getting some last-minute things done before she does. Later today sometime, I think she's leaving. So we will see. Guys, I don't know. We had another document drop, and it was the courtroom decorum. We can go over that. There was another deadline due on the 14th, which was yesterday, and that was the defense needed to get in their filing on the alternate perpetrators. And the judge had already addressed that with them and told them, you can't just come in here and say somebody else did it, or use the Saudi defense, some other dude did it. You have to give a name, and you have to give the reason why you think that's the perpetrator or alternate suspect, So that was due yesterday by the defense. It's not on the court docket this morning. So I don't know if they're like, never mind, or if they're going to bring it up in court today, right? There is speculation about that, but it is a pre-trial conference to discuss really whatever needs to be discussed, right? Because they're trying to get all these little things ironed out ahead of the trial. This should be the last pre-trial conference, but I know we have 2 other hearings set for July. As far as those alternate perpetrators go, we had, the state filed a motion in limine about the perpetrators, alternate suspects, and then the defense came back with another, with their reply, and then they had the big hearing April 9th, and the judge made a decision that day, and it was in the memorialization document that he posted. So he gave them until the deadline of the 14th, which was, like I said, yesterday. So we will see if that gets brought up this morning in court. And hold on. They may discuss the state's independent medical thing. I don't know yet. Their own medical exam. They still had to get some exhibits list done, some self-authenticate off records done. The state needed more time on the self-authentication of the records. But there's a curious thing on the case summary where it says it's like the prosecutors were reclaiming an exhibit they had submitted. I don't know if it was for updates, and they're going to resubmit. I don't know how they're looking at that, but those documents haven't dropped yet for me to read them, so I can only speculate as to what the heck that means. To reclaim to reclaim exhibits. It's a little odd. I've never really seen that before. So, what are they doing there? Were any of you watching the little bit of the Karen Read before you came in? I shared this thing with Butterfly yesterday, guys. It was like, how they don't have cameras in New York for the P. Diddy stuff. So somebody, I don't even remember who it was. It was like a network, um, did this AI thing where you could hear the opening statements, right? And this, of course, it didn't show any people, but it was really interesting. Me and Butterfly, like, we're never seen that before. So what the heck? But you could like just hear her talking like as if she was a prosecutor. And man, there's some disturbing allegations coming out of that case. From what I understand, some pretty disturbing footage being shared in that case. Oh my goodness. It might be a good thing that we can't see it, guys. How many of you guys think that the defense will bring up that Dateline episode today? Because they've already made filings in the past, right? Where they cited the social media, they named names, they named YouTube channels, they named like Law and Crime, different things like that, the networks that were putting out information about their client. And she's talked about all that in court already in pretrial publicity, right? And how big that is. Now, we all know with the gag order in place, they're not supposed to talk to anybody, prosecution, the defense, or anybody tied to the investigation like law enforcement. So is it going to be a problem? Is the Dateline episode a problem? You know what I mean? That's what I'm wondering. I think the defense will use it. I said that the other night when we were hanging out with Publicly Buzzed. I said, Ann Taylor watched this and she's livid, right? She's got to be livid. Yeah, if Ann Taylor gets the opportunity to use that to get the DP off the table, that's her end game, right? That's her end game. If nothing else she does him any good, her end game is to get the DP off the table. And they got it off the table in Lori Vallow in Idaho. Or excuse me, Lori Daybell. I'm going to try to start. I don't like saying her name anyway, but I guess I got to start saying I don't really got to do anything, do I? I'm going to call her Lori. Lori with a L-O capital R-I. Hang on, guys. I'm pulling up my other screen so I can monitor a couple of things at the same time. Oh. If I would go look at the right thing, that would be the best thing to do. Okay, I'm up. I'm running. Okay. Other screens. Oh, shoot, my phone's up in the background. All right, everything's turned down now. Everything's good to go. All right. Yeah, I don't know. It'll be interesting to see if they bring up the alternate perpetrator stuff today, if they'll talk about that, if the filing comes down. Let's see. While we're waiting, let me go check and see if it didn't drop yet. Since I looked a few hours ago, I've been doing a few other things since then. Oh, we got some new orders. Okay. I was all over this thing about 2 hours ago. Okay, so motion came in. These are all filed 13th and the 14th. State's motion to reclaim the exhibits. I gotta read that, guys. I gotta read it. It's only a little like 2-pager. Hang on, I'll bring up the screen and we'll look at that. Figure out if we can figure anything out from that. And we'll look at the ones we can before they start here in a minute. Okay, let me get the screen bigger. You guys see that okay? Okay. Okay, motion to reclaim exhibits, State of Idaho versus Brian Kohberger. Now comes the State of Idaho by and through Latah County Prosecuting Attorney and moves the court pursuant to ICR 41.1 for an order permitting the state to reclaim the exhibits in the attached state's Exhibit S1 offered or admitted at the grand jury proceedings. Huh, interesting. The state is prepared to substitute a copy, photograph, drawing, facsimile, I can never say that word right, facsimile, or other reproduction of exhibits if requested by the court. Excuse me, ma'am, if you take back your exhibit, you better replace it. Grand jury proceedings. That's Dolphin, are you listening out there? I need you up here. My goodness. Y'all, I'm gonna start thinking out loud and all the things. Y'all know that. That's super interesting because it says grand jury. Otherwise, I'd be like, okay, they just need to update something. Maybe they got another expert, new stuff weighed in. I don't know. They could have submitted something else to go along with what they already did. So it didn't make any sense to reclaim. So I don't know what that means. And the state is prepared to substitute with a copy, photograph, drawing, or whatever, a reproduction of the exhibits. That's crazy. And it was Exhibit S1. We know what some of these exhibits are. So I'm going to have to go back through some of the other filings that actually talk about these exhibits. And they accidentally tell you, they don't accidentally, but it comes out what they are. So S1, offered or admitted at the grand jury. So that's something to do with grand jury stuff, which is, I think it's going to be a problem in this case going forward because I don't know if there's some of the stuff that's going to be testified to. Is it going to be sketchy, different than the grand jury? Okay, so then they had, after that, there was a state's motion to seal Exhibit S1. And I think, that's just to ask the judge to seal the exhibit. The amended order governing courtroom decorum. That one was actually out yesterday. So second motion to seal defendant's proposed jury questionnaires. Those two were already out. Order permitting state to reclaim the exhibit. Okay, let's see what that says. You permitted it? I don't want, that's so odd. All right. Order permitting state to reclaim exhibits. The above matter having come before the court pursuant to states to reclaim exhibits pursuant to ICR 41.1 and good cause appearing, it is hereby ordered that the exhibits listed in the state's Exhibit S1 may be reclaimed by the state. It is further ordered that the state substitute a legible copy, photograph, drawing, or reproduction. Okay, so they're going to let them reclaim their exhibit, but you got to enter a copy. That is crazy. So order sealing the state's motion to reclaim the exhibit. And so we're not going to get to see what and then the notice to the state's amended exhibit list. What do they have on that? Let's see. You guys ever heard of that, to reclaim the exhibit? Maybe that's like their only one they had and they need it back now and we'll just give you a copy. Crazy. Good morning, Rachel. No, because there wasn't a 3D model of the house used at grand jury. This is something to do with grand jury exhibit is what the first document we read said. It was their exhibit used at the grand jury. So some of that grand jury stuff will be brought up during this trial. It's unavoidable at some points. Hang on, guys. I'm pulling up the feed on the side again. I thought I had it up, but I didn't, just to make sure. Got like 10 minutes, so yeah, they've had a bunch of back and forth filings about the 3D model. So this is something different. Now, S1, I don't have to go look, Rachel, because I do have some of the exhibits listed, but this one is definitely to do with the grand jury stuff. Based upon the state's notice of amended exhibit list in motion to seal filed herein, the court does hereby confirm an order that the state's notice of amended exhibit list is exempt from disclosure and are sealed. Well, that's because it's the exhibit list. Got no problem there. Okay, we went over that one with the order sealing the parties' joint proposed jury instructions regarding leading to the tip. We went over that. It's like a one-page thing. We went over that the other day. So I'll show you this, guys, on the courtroom conduct and decorum. Good morning, Carol. I think I saw you this morning, or maybe last night, somewhere in a chat. I was like, oh, there's Carol. That's what I was just wondering about, Carol. I was just talking about that as we opened up the show. Will Ann Taylor bring it up? Will she throw a fit? Will she make some motions? Because she's already filed in the past about pretrial publicity, and she has cited, specific networks, specific shows, the different things said about her client on these shows. She's already, made it known that's her thing, and that was part of the reason they took Daybell's DP off of the table. Was partly because of prosecution sanctions, but they also cited the pretrial publicity, and that was in Idaho. So Ann's already, cited Daybell's case 3 to 4 times in her filings, and will she do it again? She will. If she feels she has merit, she'll do it. And the other fallout is the gag order, right, Carol? Who gave all that information to Dateline? There was a lot of damaging information about that guy leaked. Good morning, Joe. Good morning, everyone. Thanks for coming in. Thanks for your comment, Carol. I know, I am too. And I saw you. I was like, yeah, it may have been early this morning. Was it? Who was I watching this morning? It was super early because I was up with my coffee. Anyway, I don't remember right this second. I watched a lot of stuff this morning. Oh, Dolphin. You were supposed to take them with you. I should have sent you a message and said, don't forget the earbuds. Oh, goodness. She's on her last minute preparations for her trip. Yeah, the gag order's been in place since the beginning of time with this case. It's never not been there, right? It's always been there. It was a big battle in the beginning and all that. So it's been the only one to really, the judge lifted it in some senses when he's like, enough of this redacting and sealing of some of these documents don't even need to be sealed or redacted. This is getting out of hand, which fueled the speculation fire. But now they're getting better about that, so, and not quite so testy about what they seal, because they were like just sealing everything, just no matter what it is, just seal it. And it's like, that's not cool either. It's understandable you forgot them, Dolphin. You're trying to get a lot of things, well, not a lot of things, but your last minute stuff going, so you got distracted. Okay, guys, start out reading this real quick. Let me pull it up. This is just courtroom decorum. Let me get me out of the way. Okay. And these are standard filings, of course, in almost every single case. Nothing unusual, but we'll see what it says. To provide for the orderly disposition of, now each court and each jurisdiction will have their own set of rules. They may be very similar, but there may be differences, and it is up to each and every judge independently to decide what goes on in their courtroom, right? They have that discretion. To provide the orderly disposition of this case, this order shall govern the conduct of the public and the media in the Ada County Courthouse for the entirety of the case, including jury trial, supersedes any prior courtroom conduct, orders, and case. Now remember, Ada County already got 2 huge profile cases over and done. This is nothing new to them, right? They don't got to scramble to figure it all out in their tiny little courtrooms. They got this figured out already. Thank you, Daybell couple. The court is mindful to the need to balance the constitutional rights of the defendant, the public's interest, and right to information in conjunction with certain constitutional statutory rights for the public to attend the proceedings. The court's interest is maintaining order in an environment which permits all participants to focus on their responsibilities without undue distractions, and court's interest in the safety of the public and court security personnel. With these factors in mind, pursuant to Idaho Court Administrative Rules, ICAR 45 and 49, and the inherent powers of the court orders follows: seating and attendance in Ada County courtroom, seating for victims, families of defendant, counsel, and other court personnel. Certain seating may be reserved by the court for designated individuals, including but not limited to authorized court personnel, security personnel, the defendant's families, statutory victims, and others specified by presiding judge. Public seating. Subject to the need for reversed seating referenced in 1A, seating for the public, including media, will be permitted in the courtroom as space permits. We have cameras. Everybody calm down. Pursuant to a reservation protocol established and administered by trial court administration. No person may reserve seats except as indicated in 1A above. Standing attendance when open seating is unavailable will not be allowed. Entry and exit during court proceedings. All spectators, including members of the media and the public, shall be seated before court is in session and during any portion of the trial. Standard stuff right there. No entry or re-entry to the courtroom shall be permitted when court's in session. Other restrictions and requirements. Broadcast of proceedings. Security screening. All persons entering the courtroom may be subject to additional security screenings. Handbag, backpacks, and other carry-ins are subject to inspection. Hold on, guys. I got to refresh my page over here. Sorry. Okay, there we go. Cell phone and other electronic devices in the courtroom. Cell phones, tablets, laptops, and any other electronic devices shall be turned off or be in silent mode and shall not make any sound or create any distraction. Devices shall not be used to record, photograph, or transmit any sounds, images, or video from the courtrooms used during the proceedings. Phones or other handheld devices capable of recording shall not be used. Sorry, I had to click it over here. Man, hold on, my screen jumped and it led to my other screen and I couldn't see what I was reading. Sorry about that. Laptops or tablets, okay, I'm sorry. The devices shall not be used to record. Phones or other handheld devices capable of recording shall not be used or held out of pockets, purses while the court is in session. Laptops and tablets used for note-taking must have any recording capabilities disabled and are subject to inspection to ensure that such features have been deactivated or to determine if recordings of audio or images have been taken in violation of this order. If the use of such electronic devices such as keyboards are distracting, persons using keyboards may be reseated and or such be prohibited by the court. Interviews and reporting. No media interviews or reporting shall be conducted inside the courtroom except for written reporting such as live tweeting. The public, including media, is also subject to Administrative Order Number 25-05-01 regarding conduct inside the court, inside and outside the Ada County Courthouse. Such written report may be restricted or prohibited if it becomes distracting or other good reason. Disruptive behavior. All you YouTubers, behave yourself. I'm not talking to y'all, I'm just being funny. Sorry, I couldn't help myself. Disruptive behavior. Any activity or behavior which is disruptive may be may result in removal from the courtroom. No person shall demonstratively react verbally or non-verbally to evidence or arguments. Otherwise, attempt to convey opinions related to the case while the court is in session or jurors are present or could potentially see or hear the same. Further, no person attending court may wear or otherwise display anything or make statements verbally or non verbally that in any way could be construed as conveying any message related to this case. Y'all leave them bill shirts at the house. Y'all know what I'm talking about. And then I support shirts, they're not wanted, or any political or advocacy message that could be construed as relating to this case. Now, I know exactly what he's talking about, and if you know, you know. Persons violating, they've already talked about it actually. Before persons violating this order may be removed and may be prohibited from further attendance. Now, we know in the past that certain people have wore certain things into court, supporting the death penalty. Not allowed to do that right now, and which I agree with. It's not the place for it right now. Wear it all you want to at home. Persons violating this order may be removed. Streaming of court proceedings. Hearings that are open to the public will be streamed at, and they give the link. Any prior order related to broadcasting of the jury trial in this matter is hereby rescinded. So they have a direct link where you will go. I've got the direct link too, but I've also got the YouTube link to where we can watch it as well. In case one goes down, I got to back up. So that's it on the house room decorum, guys. Yeah, it's similar. All of them are like that, right? They got very specific here with wording about these shirts because of what I just described. It's about the House bill to go on also to the firing squad versus lethal injection. But I just found out something interesting about their lethal injection over there in Idaho this morning. They don't have any more drugs. They let them all expire because they weren't allowed to carry out any more executions until they allowed more media access. And that just came out a couple of days ago. And so all the drugs they had for lethal injection have now expired. And they've implemented the firing squad. So that's not my fight. Death penalty is not my fight. But that's what that's referring to. So they get very specific sometimes, case by case. But you're right, Joe. It's very similar. And like I said in the beginning, it's pretty much across all courtrooms. Well, Judge Hippler is going to enforce that cell phone policy in this case because I know that a lot of people followed the Daybell stuff, but this one's going to be bigger than Lori's current stuff, right? Lori's Idaho trials were huge. I'm not saying they're not in Arizona, but this one's going to be a little different. And remember, we had the Google glasses over there in Delphi. We can't forget the Google glasses, Joe. Folks will be willing to try anything, won't they? So I don't know if Hippler's willing to put up with any of that nonsense. Toffin, get one for me, girl. What you gonna have? Something good? How long is that flight, girl? I bet it's long. I think she told me, but I forgot. Homeschooling. Y'all know what? I'm not a teacher. I'm a teacher, but I'm not a school teacher. During the pandemic, oh my God, I have got 4 kids, but I only had one in school. Thank God. I was like, if I'd had all of my kids in school during this darn shutdown or lockdown, whatever you want to call it, I don't think I would have survived. I'm not cut out to homeschool the babies. I'll send them to school, get them out of my hair for a few hours, and let them have at it. We got pretty good schools around here, so I can't complain. Yeah, it's hurt like Carol. Her first ones in Idaho were huge, right? And it is what it is. This one's going to be a little different vibe. About a 12-hour flight. Yep, get you a few cocktails and get relaxed, right? Get relaxed and Sleep. Man, I'd probably sleep that whole flight if I could, because I'm terrified to fly, so I would have to sleep. You got to knock me out with some pretty strong stuff to get me on that big old airplane and tell me it's going to, if you, I guess you're used to flying. People who've done it, they're like used to it. I've just never wanted to do it. I drive where I want to go, but I would have a hard time driving to Greece, wouldn't a dolphin? Why, Joe? I want an insider in the Ada County Gallery. Are we afraid the court feed won't tell us everything? What are we? There were 75 seats in Maricopa, 15. Yeah. Every courtroom's different, with their size, their seating. It is what it is. Yeah, they got bigger courtrooms in Ada County. I'm not really, I'm not going to be there sitting there trying to get in, so I'm not really worried about it. I'm going to sit right here in the comfort of my home and watch that stuff on TV, or actually here on my YouTube channel. We're all curious, Joe. We just all can't pack up and run down there like that, though. So, luckily, fortunately, we have cameras, and I will get to see and hear everything that's going down. Unless the judge gets really mad at everybody because they don't know how to behave because these adults don't know what they're doing, and he shuts it all down and says, "We're done." Then I'm going to say, "Dang, y'all, look what y'all did." Not y'all, but the people who caused it. They're going to ruin it for all of us at some point. I know it's coming. What are you curious about, Joe? Do you want to go see if he has those odd looks? Are you planning to go boots on the ground, Joe? Amen, Carol. Preach it. It is a premium. I'm all about some comfort. I'm like the comfort queen. If I can't be comfortable, I do not want to do it. Put myself in many of uncomfortable situations, over the years. It's like not anymore. I like to dress comfortably too. I don't even. I think he can. I think this guy's got it. I also read an article. I think he's conferred with Judge Boyd too, because Judge Boyd ruled the Idaho courtrooms and the Daybell stuff. I mean, that was his courtroom. That man owned it, and you didn't play with him. She didn't play with him. She meaning Daybell. Lori with a capital R. L O capital R I. I think he can. I'm going to bring up this screen and make sure I keep it refreshed, guys. We'll get underway here in a few minutes. See what all they're going to discuss today, and then we'll have a discussion after. Now, when they do go live with this hearing, I'm going to mute out because I don't want to outburst and make y'all not hear something that you need to hear, because I might laugh or I might go, "What?" You still never know. So I'll just type in chat. I'll join you guys there, and then after it's over, we'll have a discussion about what we just saw. And then, like I said earlier, though, I did drop the link to today's stream on Karen's trial into our playlist. So those of you who are joining us here today, go back and review it later if that's what you want to do. Like I'm going to do, of course, and take my notes. And then in the morning, we'll get back underway with Karen Reed again. I am curious to go back because I know the medical examiner's up there this morning, and I want to hear what she's got to say. It's important. Yeah, I don't think Hippler's the one to might be a nice guy, but he's a no nonsense kind of guy, and I'm kind of a no nonsense gal. I can't stand the nonsense and the drama and the hoopla and the blah, blah, blah. It drives me nuts. Oh, Carol, thank you. Thank you for your support. I appreciate that. Thank you very much. you guys, all of you, for being here with us all the time, joining in on the conversation. If you don't mind, hit the like button. That's all I do ask. I do appreciate any support we get here. It goes a long way and it helps, and I do appreciate it. You guys being here is the main thing to me, and I love the community that we're creating and cultivating here, and I like to do it organically. I don't promote myself a ton. I don't always post my stuff out on the X. There's some freaks out there on the X, and I'm like, I don't even know if I want them to know, right? My little community will spread the word, So I post sometimes on there what I'm doing here, but um, and I cover a lot of cases, so I appreciate you guys tuning in with us and following up on the ones we are following. Thank you, Carol. We try. We have a nice little chat group, and a lot of them are still getting up and getting their day started, and a lot of them are watching Karen read today, which that's totally cool. Like I told them, I do not hold them against any of them. If Coburger's not your case, by all means, go watch Karen read today. I totally get it. The conversations that happen over here are awesome. You guys have a lot of great input because we all have different things we bring to the table, right? And different experiences that we can talk about that may pertain to some of these cases and how we see them and view them. Because remember, these jurors are just like us. And like Joe and I have talked about in the past, two people can see the same exact piece of evidence and view it very differently. Joe and I have done that on more than one occasion. The most recent was that text message exchange, and I'm a woman, he's a man. We saw it differently, and that's cool. That is totally fine. Yeah, some people want to call him names and call him, all the things because he's not. Well, they did it with the other judge, you know what I mean? The same ones not caring for this judge or the ones who didn't care for Judge. I'm like, well, what do y'all want to do? Y'all want to go y'all want Judge Gull? We'll go get her. She might be available. But you can't always get what you want, can you? Or actually, in Koberger's case, careful what you wish for. You wanted that change of venue and you got it, and you got yourself a whole new judge that don't seem to be wanting to play ball. I mean, heck, he called their expert a conspiracy theorist, y'all. That might have been a little much, but okay. You guys, some of your comments just crack me up. And I don't need to be drinking a sip of my coffee or my Coke when I'm reading the comments because I'll tell you, I about spit my drink out several times. Joe, are you busy this morning? You want a link to come up here and chat it up with us? All right, I'm still waiting for the stream to start, guys. Did you guys join us over at Joe's last night and watch Lori's little epic whole hearing? I dropped a little short video this morning on just that one where she asked the judge to recuse himself, and my goodness, I didn't have it up in no time, and the views just went through the roof. I was like, really? People like to look at that one little section and laugh at her. Wanting the judge to recuse himself. I was thinking to myself, you know what, Lori, if other judges and other high profiles are like, no, we're not recusing, you just don't know, girl. You got to do better than that. Got to do better. But we took a look at that hearing over on Joe's channel yesterday evening after we got done with Karen Reed for the day. We went over there and reviewed that. So if you guys want to take a look at it, Rachel, can you get Joe's link into the channel, please, or to chat, please? Okay, cool, Joe. I'm going to grab that now and drop it. You know where it'll be. Let me get that over there real quick. Okay. Oops, wrong button. Enter. All right, and like I said, guys, when the hearing does start, I'm going to mute out so I don't talk over what's going on in the courtroom because I need to pay attention. Oh, you caught that? It was very entertaining, wasn't it? It was like a good laugh. And sometimes we just need that good laugh here in true crime. It was a good conversation, Joe. It really was. And you and I looking at the law aspect of it, right? The different things like that. Once that these court documents are coming out, and looking at the court procedures, and because I like talking about that legal aspect. I mean, what am I here for, right? Some salacious stories. That's what X is for, apparently. Salacial sensationalism. Whether it's mainstream media or social media, they all got that sensationalism. It's so funny how they all just like go at each other for it, but they're all the same. I'm like, what the heck? So Joy, welcome in. It's always your name just reminds me of sunshine. So Joy, you know what I mean? I just imagine sun bursting and joy everywhere when I read her name. I love it. Carol, I'm bad about that lately. I don't know what it is, if it's because I'm approaching another age, because I got a birthday coming up real fast. I'm like, what has happened to me? Why am I wanting to go to bed with the chickens and wake up at 3 in the morning and just stay up, and yeah, until dark 30? I'm back in bed. It's like I gotta stop this new routine I'm falling into. I'm not down with it. Maybe I'm just going into my next phase. The old I already said I take granny naps occasionally, but am I going into old lady phase? She was showing her true colors, Rachel says. Yeah, she can't hide them true colors. They had her all drugged up over there in Idaho for a while because she just refused to do anything but sit there and like a bump on a log and just ignore everything around her like she was on something, right? Until the trial was over. And then she had something to say. I'm tired of her, actually. I'm ready for her to go sit down and be done. I'm sure the families are completely over her by now and are just sick of hearing her name. Well, most of them. I'm kind of sick of it. There ain't no figuring that lady out at this point. It's not hard to figure Lori Daybell out. And not my opinion anyway. I think maybe because I've been looking at her for too many years. Been looking at you a long time, Miss Lori. I'm done. I don't think she can say one thing that would could redeem herself for anything. I got questions for Zulema though. Are you the one that introduced certain elements to you little? Well, let's see, what's the right name I want to call that little group of women? Because they don't deserve one name. This little gang of offshoots, whatever y'all called yourselves. Yeah, I know a thing or two, Zulema, and you've had some curious things to say, and it made me wonder, girl. Energy matched. Yay! I have Firefly taking on a new job and Butterfly getting rid of her old one. Yay! Good for you, girl. I know you're ready to move on. Good for you. She's ready to move on. Butterfly is ready to fly, y'all. Get back, world. Oh, Dolphin, you're out there getting the luxury. You make me want to take a trip and a spa day and all the things. I'm living vicariously through Dolphin, you guys. I just do. Like, I don't have like nothing else to do, so I'm like, I'm just gonna live through Dolphin and look at all her pictures. I need a spa day to go get some shampooing done. Why, you might be there longer. Does your hair grow like really long? I know you got it cut a while back. My hair gets too long. I get aggravated with washing it and rinsing it because it takes too long. So I like want to whack that stuff off. Had long hair all my life. At some point, you get over it. There's a time my dad would not let me and my sister cut our hair. I think I was 15 before he let me, and that stuff was so long. We're still waiting on the stream to come up, guys. They haven't started yet. And it's 10:19. Why not? Everything's refreshed. Let me check something really quick. Let me do this. Because I'm not liking that. I don't understand. Well, there's always delays. You never know. Okay, Butterfly. Thank you. Oh, I know what I did with it. Yeah, Ada County's an hour behind me. It's only a 1 hour difference between me and Ada County. Okay, they apparently have not started yet because here's also one from a. Oh, let me silence them because they're in my eardrum. Okay, stream starting soon. Yeah, their mountain time or whatever their time zone is. I don't know. Go look it up. But they are an hour behind me. That's all I do know. I know Eastern time, Central time, Eastern. Everything else, whatever it is. Yeah. Thank you, Rachel. It's 10:22 here, so it's 9:22 in Boise, Idaho, Ada County. Moscow's 2 hours behind me. Ada County and Latah County are on different time zones. Kind of like Florida. We're down here on the Panhandle. We're a different breed. You go down there and cross the Chattahoochee River, your time changes to Eastern. I'm on Central. So yeah, for whatever reason, they're just starting late. They don't have to give us no explanation. I know I saw some mad tweets the other day about how they wanted certain people, and I was surprised at the ones demanding it because they're Karen Reed supporters and were just mad and livid because we didn't find out why court was canceled. And I'm like, well, geez, calm down. Yeah, Idaho has 2 time zones just like Florida. That's okay because I have a time that me and Dolphin are hooked up. I'll always know what time it is where she's at when she's traveling, and she knows what time it is here in my town while she's traveling. We made sure we fixed that like a week and a half ago, so we can bring her on when I need to, or when yeah, while she's on some downtime on her trip, she may pop in and say hi to us, so we can keep up with each other's time, make it a little easier. So I have that little cheat sheet now saved. I can go look at anybody's time now and figure out what's going on. It can be, yeah, having 2 time zones in one state. I'm so used to it though, all my life. We just always knew this end of Florida and that end were on different time zones. Because I'm literally on the opposite end of Miami. Like, we couldn't be further apart. I'm the beginning and they're the end. Because I'm down here by the Alabama line, also known as the Redneck Riviera. Do you guys think they're going to bring up that Dateline stuff and it's going to become a big issue? What kind of an issue could it be besides getting somebody into trouble over the gag order? I know I saw a few people say, and these are not people that are just random. As I do, there's some random tweeters out there I ignore, just keep scrolling because it's like I don't even. But so a few people were wondering if the FBI is the one that leaked that stuff to Dateline. I'm like, oh, dude, I don't know. I don't mess with the FBI like that. I do not want them banging on my door. Why would they? Why would you? It's odd that some of that stuff got leaked. I don't mind that it did. I'm not here to dispute that. I'm just saying, is it going to be an issue? You know what I mean? These attorneys are getting super creative lately. Just like them not wanting to use certain grown up words in court. Stefan Stearns wanted the same thing. They can't say the word murder in court. Well, isn't that what happened to the victims? Like, really? We're not going to turn around and point our finger at you and say you did that. We're just going to say it was done. And now we got to figure out if you are the guy that did it or not. It's like we live in a world of 3-year-olds all of a sudden. I don't want to pull up a filing and start reading something, and then we have to stop and they go right back to the feed there. I wonder if the state's done their independent medical testing yet of Brian Koberger. They can only test to the same things that this defense tested and have planned to introduce into court evidence. So the judge was pretty specific about that. He granted the state's motion in part and denied it in part. And B, he also agreed that both parties, state and defense, could watch the procedure or the test being performed via, closed TV there. Koberger can't see them, but they can see him. Yeah. It may be hard to figure out for them to even figure out who did that leak, Rachel. I don't know how they would go about figuring out who did that, right? But if those so like the photos of Koberger and the photos that he browsed on his phone, all of that, and they showed those images on the Dateline. Did someone take those images out of the evidence? And you know what I mean? All that right there has to be looked at. Because they were showing the stuff that was literally on his phone. That's crazy. That's really one of the most explosive Datelines you've ever seen. Because they go hard, and we've all known that. We've all known they have before. But they really went deep on that one. It was one of their biggest episodes. And the only reason I would have an issue with them with that type of thing is if it causes a problem trial. You know what I mean? That's where it's like, oh, was it a little too much? I don't know. And honestly, it doesn't make or break me, making it didn't sway my opinion on whether I thought he was innocent or guilty because I already had my thoughts before the Dateline. They just confirmed stuff we kind of already suspected. And I could still walk into that courtroom and go, uh-oh, when they start showing certain evidence. Or this is all you got, or that you go, I hope it gets better. I can say that honestly when I see it in court. You know what I mean? It may be so overwhelming that this like, oh boy, he's never getting out. Yeah, those photos, telling, like if you're leaking information, you're telling somebody something, that's one thing. And if you show a little receipt here and there, but man, they had a lot. No, Rachel, they showed images they claimed came off his phone, right? Images that we've never seen before. And I've seen it all with this case. Anything that was ever leaked, anything that was ever discussed, all this crazy, crazy rabbit holes we went down. There's way too many to list. They literally showed things on that Dateline that we have not seen before. but they confirmed things that we had seen before. Well, I guess you can call it confirm in their eyes, right? And a lot of some of the information they talked about has been out there. I meant like the Grove pool party and the people they talked to from the Grove. Those guys have been out there for a long time. We knew about a lot of that already. I think one thing that was new is about the two. Well, I think we did hear about the one that was married that aborted her husband, but there was a lot of that stuff in there we did already know about, but there was no confirmation of any of it. It'll be interesting to see how they deal with it going forward. I bet whoever did what else could you leak at this point, right? You pretty much let it all out there, including all that 1122 video. And how will that impact the case going forward, or will it at all? I don't know yet. Do y'all think that sometimes that might be a little much? I'm curious. I'm like gauging everybody right now. I want it because I don't want just my thought. I'd like to know what you guys think about that kind of stuff too. Do you think that was a little much? Do you think it may affect the case? You know, you think it was okay? Because there's no right or wrong answer. There honestly isn't. I keep refreshing the page, guys, and I got two separate feeds pulled up so we can make sure we don't miss out. Like they're 30 minutes behind already. Are they having some kind of little argument in the courtroom, or is somebody not shown up yet? Goodness, there's no jury present. Let me see if they gave an update here. Court was scheduled to start 20 minutes ago, so things have obviously been a little delayed. And KTVB has a reporter in the courtroom. Oh, let me go troll Twitter for a second. So there is somebody I wanted to watch today. Keep an eye on anyway. So I think he's in the courtroom. Just see if we can get an update on what's going down. No, he's not there. Or he's in there, he's not posting yet. Okay, let's see. Yeah, Carol, there was some obvious violations there. Okay, the KTV just hit, here we go. Let me get the stream up. Let me get the sound on.
Identified are present. We are in the public session now.
I'll mute out, guys.
I have
He said public session. They had a closed session. Okay.
my own agenda for what to cover today in the pretrial motion, and so I'm not sure what you have. I didn't receive any specific motions to cover today, other than I think the ones previously submitted by defense related to questioning of the jury. As I indicated, I don't intend to discuss in the public forum what specific questions would be asked of potential jurors, because I think that inhibits the ability to get frank and unprepared answers from potential jurors. And so we may have to cover part of that in a session at the end of the day. I think we can talk about it generally without discussing the specifics, but if we need to go there, that's what we will do. Apart from that issue, as what I intend to do is kind of break down the trial process through stages, and as you have issues or questions about whether how to handle something or how the court handles something, that's your opportunity to ask as it relates to that phase of the case. and we'll just sort of proceed in that fashion. So starting with some general issues, I just wanted, and a lot of this is unfortunately going to sound like me simply lecturing about what I want and don't want, and that certainly is a large part of it, because if you know what I expect, I think it makes your job easier. And so I, particularly where I can't recall whether Ms. Massoth has had any trials with me or not, but I know she's been in front of me a few times, but the rest of you have not. And so it's, I think, important that you get that information straight from me rather than from the sources that you may get from asking around. So to start with, I'm not a fan of surprises, as you may have figured out by now. I want to know in advance, as far as possible, when there are issues that need to be addressed. That includes evidentiary issues. So if you know that you're going to object to some line of evidence, or you anticipate that there's going to be objections to a line of evidence, I don't want to wait until that is offered in the middle of trial. For a couple reasons. One, I don't have the opportunity to look at the issue to the degree that I would want to in order to give you the best ruling that I can. And two, it doesn't give you the opportunity to make the best case for me that you can for either excluding or overruling any objection. And perhaps even more important than all of that, from my perspective, is in what is already going to be an quite lengthy trial, it just extends it. And nothing frustrates jurors more than sitting around in the juror room doing nothing while we're in here doing something. And so that helps guard against that and minimize that amount of downtime that we may have. So we'll have periods, as I will explain to you, before court each day and after court each day, where if you are anticipating issues that are coming up, that's the time to talk about that, not in the middle of the trial itself. I did receive the parties' stipulation regarding how to handle the IGG tip, if you will. I'm fine with that proposed instruction, and so that will be given. I think I'd asked you also to work on instruction related to the use of the terms surrounding touch DNA and other variations about that in the event that I decide to correct somebody about the use of that term. As I said, with respect to the professionals in the DNA community itself, I'm not going to prohibit it in the sense that, you know, I'm going to sustain an objection. What I would likely do is to clarify with the jury, if the parties want me to, about that being simply a convenient title and not meaning to imply an actual source of or method of the DNA being present. And so if you haven't worked on that, please do so to get me an instruction you both can live with. Otherwise, I'll end up drafting one myself, and perhaps neither of you want to live with it. So with respect to the model, I think referred to as the dollhouse by Mr. Thompson, has that been produced for the defense to inspect?
It has, Your Honor. It's actually here in this courthouse, has been for a few weeks, and Mr. Hurwood facilitated the defense viewing it yesterday.
Okay.
It is available for the court's inspection well if the court would like to look at it. And just for the record, to the extent that the model was characterized as a dollhouse, I think that was an inappropriate characterization. It is an inappropriate characterization. If I'm responsible for it, I assume responsibility, but that's simply not an appropriate way for it to be described, given what occurred there and the victims.
I think a better term is simply a model.
Yes, sir.
Rough model, given that it is admittedly not to scale precisely. So, Ms. Taylor, any record about that? You had a chance to look at it?
Your Honor, we did. We were able to bring 2 experts in per our request yesterday, and we appreciated being accommodated while we were here. We do have a remaining question about where the model house will be stored during the course of trial.
Where are you storing it, on the 3rd floor?
Yes, sir.
Okay. So it sounds like it's stored with the evidence vault of the prosecutors down there. And so I suppose if she needs to get access, or our experts do, we can arrange for that as well.
I should have asked a better question, Your Honor. When it's brought in
I
as a
see.
demonstrative aid, I am curious about when it's not being used by the prosecutor or the defense and a witness, where it will sit in the courtroom.
I will find some place not in the courtroom, because I don't want it in the courtroom when it's not being used, but nearby in the event that a witness does wish to use it.
Thank you, sir.
The other thing that I would point out, as it sounds like you've been, at least to some degree, working together, and I appreciate that. As you come to stipulations on agreement on things, it's important that those be reduced to writing for your own protection. Because too often what I see is in the middle of, for example, trial, well, Honor, the other side said that they were going to stipulate to that, and then they're not. That leaves me in a difficult position, because I wasn't part of those discussions, right? And so for your own protection, I think it's just important that you get those reduced to writing as much as possible. I did receive the parties' spreadsheets on the exhibits, which we'll go into a little more when we get to the exhibits portion of today's menu. But I appreciate getting that. There's some questions that I had about it generally, and then some more homework to do on it. In terms of the witnesses, I had asked, and I think my law clerk reached out to make sure that we get a description of those witnesses, kind of like if they're, who they work for or where they're from, something that will allow me to categorize those on a juror questionnaire, so that they don't just get a list of 300 names, but can say, all right, these are witnesses, these people live in Pennsylvania. These are witnesses that work for the FBI, these, right? And so that they can put in context those names, which will be result in a more accurate review by them of those names, to see if they know anybody. And I'm not sure if that's been accomplished yet or not. And so if you haven't done that, please get that to us as soon as possible so we can incorporate those. I think the state had, and last I heard, but it's been several days, the defense had, we were still waiting for someone from the defense.
And I believe that that's been provided. My hope is that it was sufficient, because I think it came back and we re-provided it.
Okay, I'll check.
If it's not sufficient, let us know.
I'll check on a break to see where it's at. All right. So I did, as I indicated this morning, receive the defense's proffer regarding alternate perpetrators. That will be sealed per request, I'm assuming per stipulation. And I want some additional information. What I'd like is by the 23rd, if possible, for the defense to do two things. One, provide me with whatever actual evidence you have that supports those allegations, rather than just allegations. And two, provide for me how it is you believe that what you are offering is admissible. Because it seemed to me much of what you had put in there was fairly potentially fairly objectionable in terms of admissibility. So I would like to see that. And then I would have the state respond by the 6th, which is 2 weeks. And then I would propose a hearing on the 18th.
Your Honor, on June 18th, Ms. Massouth has a conflict in the morning, but we could do an afternoon hearing on that day.
Can we do the 20th? The 19th is a holiday, and the court is closed. I'm just not sure whether it can be done in a half a day or in the afternoon or not, depending upon where we're at, is my concern.
Your Honor, for me personally, the 20th is a little bit of an issue for personal reasons, if we could avoid that date. If we can't, then I guess we can't.
Well, let's, can we start by like noon on the 18th?
12:30 or 1, I'm in federal court.
All right, let's do 12:30. Are you handling those issues?
Alternate perpetrator, I'm, yes, very involved.
All right. Let's do 12:30 on the 18th. All right, next I want to go to juror questionnaire discussion. Before I do that, this was that was, as I said, sort of a catch-all category. So I want to ask you if you have questions now, because I suspect it will fit into, if you do, a more specific category, and we can address it at that point. But if you have a question or concern about anything we've talked about thus far, now's your chance.
I don't believe so, Your Honor.
No, Your Honor, thank you.
All right, juror questionnaires.
I don't know what just happened. It's froze. Let me refresh it and see what happens. Like their whole thing just froze up. Oh, can you guys hear me? What just happened to their feed? Wow. Hold on, guys. Let me pull it back up. I don't know what their deal is. The other one on my phone did the same thing. Okay. Let me try a different feed because that one is sure not working all of a sudden. Damn it. Oh, it just went offline completely. Hold on. I don't know what they're. It's back. They have an issue. They're still having an
Competing
issue.
have the right to be present, but when the questionnaires are administered, but I suggested to you that perhaps your time is better spent in reviewing the questionnaires than watching people fill them out. The process will be such that as we bring groups in to fill those out, those will immediately be scanned and then provided to council on a shared drive. And so I guess I wanted to get your feedback on whether I suspect this is a all for one or not proposition.
Thank you, Your Honor. My understanding is we have both agreed that there's no need for counsel from either side to be present during that stage. We'll focus on the tasks at hand.
Okay, very well. Does that accord, Ms. Taylor?
It is, Your Honor.
All right, very well. So as I indicated, you'll be given access via shared drive. You can do two things. One, you could save those over to a copy over to a drive in which you can make edits, or you can print and make hand edits, or you can just keep track by notebook and juror number. If you want to do the printed version, you'll need to bring your own printer and supplies in order to print those off from your war rooms. The plan will be to take the universe of jurors who are summoned and then scramble them randomly and assign them what we call a scramble number, 1 through 10,000. And then we will bring them in to fill out the questionnaires beginning with 1. So that the questionnaires that you receive first will be the jurors most likely to be in the line of fire, so to speak. Because once we have enough jurors, we'll stop. So that's the plan. Anybody have any concern with that?
No, sir.
No concerns, thank you.
Technically, under the rules, you are entitled to watch the scramble process, which literally involves the jury commissioner hitting a button. I don't know if any of you want to be there for that.
No, thank you.
We'll waive our presence for that, Your Honor.
Very well.
They got to speak up or mic up.
I do want to stress the security and confidentiality of the juror questionnaires. As I'm sure you're aware, pursuant to Criminal Rule 23, those are extraordinarily confidential. The copies that you receive will be, we'll maintain a copy, obviously, for appellate purposes, but the copies you receive will be returned. And the defendants, they're supposed to be essentially attorney's eyes only. I'm fine if you both agree to allow an investigator to see so that they can be doing, whatever online investigation they feel appropriate as you go along. Doing that, in terms of the defendant, his access has to be with attorneys present. In other words, he can't have a copy or whatever to go back with him when he's not with you.
That makes sense, but I have one question for the court. In addition to our investigators, we have 3 that are working on the case. We would request our paralegals be allowed to assist us. Just with the magnitude of the task, we'd like to have the assistance of our paralegals in organizing and reviewing.
Sure.
And likewise, Judge, we would hope to use our administrative assistants in the process, and they are part of our staff.
Sure, and by court and bar rules, you're responsible for their conduct, and so you'll need to make sure they understand the confidentiality of those questionnaires, and it's really your ticket on the line for their behavior. So that's fine. But I do want to stress that confidentiality because it is part of what I'm giving the jurors on the instructions, is letting them know that there's a very limited number of eyes that will review this and that the public never will. So. The plan will be to try to process the first questionnaires. As I said, you'll get them each day and go through them. After 3 or 4 days, we will start to have hearings. Those will be sealed hearings because we'll be going over the questionnaires in detail, in which you folks identify the concerns you have with the questionnaire answers, specifically whether there's a motion or agreement to strike a particular juror before we ever have to bring them in based upon the questionnaire answer, right? And the idea is to dismiss those who are unlikely to be put on the jury because of either perceived bias, knowledge of the case, or hardship. And so, I think it helps everybody if we are trying to agree to that as much as possible. It's the reason that we are summoning as many people that we are, is so that we can really cut through the chaff and get to the wheat. Any questions about the juror questionnaire process?
Sir.
So the next topic I have is voir dire, more specifically. Traditionally, the way, as you know, voir dire works in Idaho is the court first does its voir dire, touching on some essentially statutory kinds of bias or knowledge. And then counsel is given that opportunity. And so much of what would be the court's voir dire, I have incorporated into the questionnaire so as to limit my role in actively questioning the jurors or potential jurors. I may follow up on some of the answers given on the questionnaires if I feel there's a need to. But otherwise, the time will be yours. What I intend to do, and I'll get your input on that, is using a model very similar to the model Judge Boyce and I came up with in the Daybell case, bringing in groups of anywhere from 15 to 20 people at a time, having a general session of questioning by the attorneys, approximately 30 minutes aside of those folks, get through challenges for cause or dismissals for hardship, et cetera, of those folks. And then who's ever left over of that group then would be subject to individual questioning by the attorneys. And so the jurors that are left over will be taken to, for example, the jury room and wait in there. And then we'll bring the jurors in one at a time to answer questions from counsel. The goal is, I'm not going to stop you if you're getting important information that needs to be got to, but the idea is after that more group discussion, the individual voir dire will be more for very sensitive topics, also for knowledge they have about the case from media or otherwise, because I don't want them to talk about it in front of other jurors. And so, and then other topics that you sense were too sensitive to talk about in front of the others. Hopefully, we can get through each of the individual jurors in 10 to 15 minutes apiece, but we'll play that by ear. We'll see.
Ask a question?
Sure.
So the 10 to 16 people in the general session, is that going to be the court's few questions and then each counsel has general questions? And just to make sure I understand, then whoever's left from there, we pull in and then we talk about case-specific information, the media items?
Media items, correct.
Okay. And would you envision that during the time we talk about media items, I can also find out their views on capital punishment?
Yeah, it may be that you are able to talk about that with the larger group to a degree. There may be some who appear sensitive to that and prefer to talk about it outside, and we kind of play it by ear. So it's not a subject I'm going to forbid from being discussed in front of the larger group. And you'll have limited time with the individual, so you need to balance how you're going to use that time.
We may have to see how it plays out, Your Honor, but in my view, talking about the views on capital punishment is fine in a bigger group. My preference would be to be able to get the media items, people that aren't going to make it, to let them go before we do that. I think it would save time to have them gone before we do the capital punishment views. If we know they're not coming, they're not going to stay because of media coverage and those kind of beliefs and views, it makes more sense to have them go before we start talking about something else. My concern is the amount of time and that the media coverage items might find their way into a discussion of capital punishment.
Well, I will make it clear to the jurors that they're not to discuss anything they may have heard in the media during that general session. And we'll play it by ear. If it's not working, we can change it, right? So let's, and this is very similar to the way Judge Boyce had done it. I think it worked well. They got a jury fairly quickly. Now, as much as the attention was in that case, obviously this one seems to have more publicity. But I think that handling it with first going through the general, because we're going to lose people based on hardship, based on, have they made up their mind? Yes, right, kind of stuff. And so we don't even need to talk to them. And then we can get into the issues, or they may, simply give a view of capital punishment and that one that it's clear that they're not qualified, either one side of the coin or the other. But if you want to deal more, if they're hedging or you're sensing some concerns, you can use that follow-up time in individual session to follow up on that rather than trying to do that in the public session. Any questions about that, just in terms of how the questioning will go? So my intent in terms of public access to the voir dire process is that during the group session, victims and defendants' family will be present. A small number of public seats will be available. And then it will be streamed to a larger room in the courthouse for anyone else in the public that wants to watch. It will not be broadcast outside of that closed circuit, because then I lose control of the recording in the event that a juror's identity is revealed, and then I get all the internet sleuths out there trying to figure out who everybody is. And I want to protect the juror's privacy as much as possible in that regard. And so this does allow for a public access is the right, but also allows the court to tightly control that process. And then the individual voir dire will be counsel and the defendant only. And there'll be no stream.
Potential jurors faces and names obviously won't be broadcast.
Correct. The faces will not be broadcast, and you are to only use their scramble number as their identity throughout this. So they will never, you will never speak their name, nor will I or the court. It'll only be by that scramble number, and the camera view will not show their faces.
The juror number by which we'll name them, will that be on them, or does this court use paddles so that their numbers can be held up when we want
They'll
to
have a
observe?
laminated paper, like 8 by 10 paper that has cardstock laminated that has the number on it.
Thank you.
And it'll be the scramble number, not their original reporting number. My goal is to try to get through 4 panels a day, which may not seem like it's much, but I know from the prior trial that they struggled to get 3 a day. So my goal is to try to get to 4 a day, but I want to get at least through 3 panel a day. The plan would be is once we get through the number of jurors we need to sit, including alternates and peremptory challenges, plus a few extra in the event something changes before the time we exercise the peremptory challenges. Once we get that number, and let's say that number's 50, that's where we would stop and then go to the peremptory challenges. Does that make sense? Any questions about that?
Just to clarify that I understand it, we'll get enough people that we get 50 that have not been challenged for cause and then exercise.
That have been passed for
peremptories.
cause, correct. So once you get that, if you will, struck panel, then we will exercise the peremptories. With respect to the number of jurors, prior to Friday, I had intended to use 6 alternates, and after Friday, I intend to use 8 alternates for a total of 20. That's about the maximum that I can fit into the jury box that we intend to use. So that number, 20 plus strikes, which would be 12 strikes apiece pursuant to the rule, gets us to, I think, 44. And so the plan would be to get, 50 to 55 that have passed for cause to bring back for the peremptory challenges in the event that we lose somebody for some reason in between. Any questions about that process? Okay. So, and then when we're exercising the challenges, what I do is I give you a time limit geared to the number of peremptories that you have. So here, for example, you have 12 peremptories, give you each 30 minutes to exercise those. And it's a chess clock. So while the paper is with you, your clock is running. And once you hand it to the bailiff, it stops running and the other side starts running. Once you reach your 30 minutes, absent some showing of something happened outside your control, then your peremptories are over. Now, that's usually I give 1 minute per peremptory in the typical trial. I'm giving you far more than that here. It shouldn't take that much time, particularly with the number of people that you have keeping track of everything. If you both pass on a round, or let's say the defense passes at the end of round 4, and then the state passes at the beginning of round 5, that ends the use of peremptory challenges, because you both have said to me, by passing consecutively, there's nobody that you want to strike. So understand that rule as you go in. After the panel is selected, the the jurors and the alternates, which the alternates won't be determined until deliberations, when by lottery, who's ever left will be determined to be the jurors, and the alternates, those who are drawn by lottery to be an alternate. But that group of jurors, and so the 20, will be taken to another location in the courthouse. I will briefly meet with them, simply to introduce to them the people that will be talking to them, which will include the trial court administrator, the jury commissioner, and Judge Cawthon, who will be acting as it relates to this case as the administrative judge during the trial, to help them understand the process that we will use for juror security, for juror privacy, for reporting, and all of that, to answer any questions they have about that process, so they know where to go to ask questions about the process, and sort of, if you will, onboarding them. Counsel won't be at that, nor will I, other than to introduce the people. And then I will leave so that I don't inadvertently hear anything that I shouldn't hear on my own. I want to stress the importance of no contact with the jurors in any way by you, your staff, your witnesses, anybody affiliated with the case. And so they need to be instructed as to that. So if the juror, if you happen to see a juror somewhere else in the courthouse or at the grocery store or at the coffee shop, you're not to even engage in pleasantries. Turn tail and run the other way as fast as you can. If you have any contact with the juror, you need to report it immediately to myself and to opposing counsel, so we can then make any inquiry that we need to. I issued yesterday an order in this case regarding sort of the rules of the road for those attending the trial, as well as an administrative order that I imagine will be on the court's website here, if it's not already, outlining some of that as it relates to outside the courtroom. So my order in this case relates to the courtroom. The order, as I signed as administrative judge, relates to the courthouse at large. Make sure you have reviewed that and make sure your team understand that. There will be portions of the building that will be off limits to the public and to you. So make sure you understand that as well. I think I told you when you were here to look at the facilities, it's important that we know where it is you intend to stay as soon as possible, as well as any witnesses you put up, et cetera, so that to the extent that we ultimately may need to sequester jurors, which once it goes to deliberation, we will have to at a minimum, that we steer you away from whatever series of hotels that we've reserved as potentially available for us to use, that you're not there. So let the staff know if you intend to stay at a hotel, if you intend to put witnesses up at a hotel, if you intend to have staff stay at a hotel. Let us know where that's going to be. You will each be assigned a conference room outside the courtroom, and you'll be given a key to it that you may lock each day, that nobody, including janitorial staff, will have access to, where you can keep your papers and files if you'd like, or other materials, and use to meet with witnesses, et cetera, as we go along. All right, before we turn to the trial itself, any questions about the jury selection process or the jurors?
No, sir.
No questions, thank you.
So the trial itself, the plan is to go from Monday through Friday with the session with the jury beginning at 8:45 each morning and ending at 3:30. Once we hit a sequestered phase, whether that be, for example, in a penalty phase or earlier in the case, should it become necessary, I will likely extend the hours of the trial to fill up the jurors' days. Part of the reason to give some time at the end of the day is so that they can do the errands of life that they need to do. But if we are hosting them, so to speak, we don't have to worry about that, and I'm sure they'd rather have their day taken up moving forward on the case. So that is the general plan. Counsel and the defendant dressed, ready to go at 8:15 each morning. From 8:15 to 8:45, if there are issues to discuss, that's when we will do them before trial starts. As I encouraged you when I first started this morning about this, this would be a really good time to discuss anything that you've just uncovered that might be an issue in the case. We will likewise have a period at the end of the day from 3:45 to 4:30-ish to similarly address issues that may be coming up the next day or in the near future. At this time, I do not intend to have trial on October 2nd and 3rd. Because of a previous commitment that I have. I had talked to you before about potentially being gone on the 14th and 15th. As of now, I've been able to make alternate plans. So for now, you should plan on being here for trial on those days. Holidays that I could spot quickly on the calendar include September 1, October 13, and November 11. So those are holidays for which there would be no court, with the exception that if we are sequestered, we may have trial, and we'll address that as we go. Because I can't send jurors home for the holiday, and so we might as well use the time. Any questions about that trial schedule? Okay. All right, in terms of special needs that you may have for trial, I'm assuming there's no need for us to have interpreters for any witnesses.
No, sir.
And then technology needs, be sure that you make sure whatever technology you intend to use works in the courtroom in which we will be. The best way to do that is to contact Ms. Barrios, the trial court administrator, and reserve a time to come down and try it out. I also suggest that you use on your team somebody that is far more technologically savvy than certainly I would have been in your shoes. Perhaps you are, but it's important to have your own IT kind of person there to deal with any issues that may come up. If you have litigation presentation software and it's not working, you might get a short recess of a few minutes to work it out. But if it's after that, we're just going to move forward and you'll have to figure out something else to use. So it would behoove you to have staff there that can deal with that. Likewise, in the event that something comes up last minute and there's a need to redact some portion of audio or video or other presentation, that you have somebody there that can do so quickly and knows how to do so quickly. And I would encourage you to plan ahead to have alternate versions of such things so that if there is a concern that's unresolved going into it, you have version A and version B you can use depending upon what the outcome of that may be. Any questions about technology? In terms of what we provide, it will be a overhead, what we call the Elmo device, which is the device where you set a piece of paper down and it projects onto the screen. And then we have a HDMI link for your computer to present whatever you want to from your computer. That's it. That's our technology. So anything beyond that, you'll have to bring. All right. Let's talk about seating in the courtroom, counsel table, and the trial broadcast. Each side, I think when we toured the courtroom, each side will have two counsel table put together, which should give you, depending on how closely you want to sit together, anywhere from 4 to 5, maybe 6 seats at that table to use how you wish for yourself and your staff, and in the defense's case, the defendant. As I also indicated, I would provide a small table behind defense because they're not really as close to the bar as the state would be. A table behind you where you can have staff, 2 to 3 staff members. The state will have some room behind the bar, directly behind them for its staff. What I need from you are numbers. Understanding the space that you have in the well. How many seats do you need? How many seats are you requesting and how many seats do you need are two perhaps different issues, but in terms of requesting, this does not include, for example, the victim's family or the defendant's family, but for staff. So apart from the 2 or 3 seats behind you, I'm assuming that's enough for you? For the state, likewise, 3 seats, 4 seats?
You should be able to make that work, Judge.
In terms of reserve seating for the victims, it will be for those statutory victims that was agreed to by the parties. And for the defense's family, it would be those 4 members that were identified in terms of reserve seating. What I would like to do, though, is I suspect that it's maybe that everybody won't be at trial every day. And so what I would like, is for those that have reserved seating, in particular the victims, and I should point out I am going to reserve 2 seats for the 2 surviving roommates who are technically victims of the burglary. I don't know whether they would have any desire to be here. I suspect not, given the way they've been treated in the media, but if they do, that they would have seats available. But anybody who has reserved seats, I'm asking that they notify the trial court administrator what their plans are for each week. So if you tell me you're not going to tell the TCA, I would like to know, for example, we're not going to use 3 of the seats on Tuesday. So that we know, so that we can make those seats available for the lottery system, or it's not technically lottery, it's a first come system on a computerized basis. But if we don't hear from you and you haven't made arrangements, we will assume that you don't intend to be here. So it's important that each week you let the trial court administrator know. She'll give you an email address if you contact her, where you can send an email to tell us whether you'll need all of your seats or not that week, and at which days you won't. That goes for both the victim's family and the defendant's family. Right now, the plan is, and this is subject to change, to have a reserved seating, I don't want to say reserved seat, a seat selection process by which people can go to a website each day and at a certain time, and it's kind of like buying concert tickets, indicate a desire to have a seat, and the first X number that are available that get through will have a seat. It will be necessary to bring identification to show that you are who you are, or are who you say you are, to get into the courtroom. Again, that may be subject to change. I think the intent is for Judge Cawthon to have a town hall meeting with media in June at a date to be determined later to go over sort of what that process looks like so that gets, so the media is aware and so that then it gets publicized to the general public that would want to be here. My intent at this point is to allow a stream of the trial proceedings controlled by the court to be run on the court's, where, if anybody's watching today, where it would be today, on the court's broadcast page. The views will include counsel table, the podium, the witness stand, and the bench. There will be no production of the video, meaning there'll be no close-ups and zoom-ins and zoom-outs and things of that nature. It'll be the static views.
Before the court goes further, when we're talking about the reserved seating for families in the courtroom, if we have some other members of Mr. Koberger's family that travel and want to attend the trial, can we request an extra seat for a day for them?
Yeah, we probably be able to accommodate a few days here and there, but seating's going to be very limited, right? And so I don't want to extend that beyond the immediate family as a general rule, but if there's a specific day or two where there are going to be a couple other folks in town, talk to the trial court administrator, and she'll see what she can do.
In addition to that, we have one other person on our team that would like to have sit with the victim or with Mr. Koberger's family. It's not somebody who would testify. So if we could have 5 seats, it's somebody who will just assist them as the media might try to talk to them
Sure.
a lot.
All right, I don't have a problem with that. I'm assuming the victim witness coordinator will want to be there as well, so.
And Your Honor, as the court is aware, we have, unlike most cases, we have multiple victims here. So we will have multiple victim coordinators to work with separate families. We will coordinate that with Ms. Barrios' office to let her know.
Are you talking about one per family?
Hopefully not like that, but we're
Thank
going to
you.
need to split at least, we're going to need to have at least 2 separate groups.
All right, let's try to keep it as limited as we can, just because seats are at a premium, but.
Yes, understood.
Right.
Your Honor, may I also ask the court in regard to the live stream from the witness stand? I believe that we mentioned this, at least in passing, in our trial brief. State anticipates that we may have witnesses who, for reasons the court articulated about the other 2 victims, surviving victims, that a public live stream where their images could be captured and played games with in the media world. Is it possible for the video of that live stream when they testify to be shut off and just have the audio? We also may have a small number of law enforcement witnesses who also do covert work, and broadcasting their images publicly would be desirable. We will advise the court. We've asked the agencies to identify anybody in that capacity and to specify the basis, which we'll bring to the court. I just wanted to anybody in that capacity and to specify the basis, which we'll bring to the court. I just wanted to anybody in that capacity and to specify the basis, which we'll bring to the court. I just wanted to
God, I don't know what's happening with that thing. It's not on my end.
give Your Honor a
I'm
heads
checking
up.
it because they keep going in and out for some reason. Now they-
Face will not be shown
Okay.
during the broadcast. Face will not be shown during the broadcast. In terms of those that work covert, I gotta see where the parties land on that. If they weren't covert in this case, I'm not sure about that. I'll have to think about that, and you may have to convince me, because I think there is public interest at play here. And so we'll talk about it.
Thank you. Yes, sir.
And as for anyone else, you're going to have to really convince me because of the public's right and their hesitance.
Oh. I'm working on it, guys. I don't know what their deal is.
Other folks who may be shy, probably I'm going to have to weigh heavily the public interest there.
Agreed, sir.
Your Honor, I wonder if the same could be accomplished with a room where there could be a feed for certain bits of testimony to a larger group. I mean, it's still a public open courthouse, and live streaming something that gets captured for millions of viewers that lives on for a very long time might be different. And I can work with the state and then give the court a little bit more on that, but off the top of my head, that's what I'm thinking.
It's going to have to be a very compelling reason to do it. So aside from victims, while we are open in the sense that the people in the courtroom, the likelihood is we can't fit everybody in there that wants to be in there. And if I start not broadcasting the testimony, the full testimony of people who would otherwise prefer not to, that's going to fill up, that's going to be a large number quickly. And the best way that we have to ensure that the public is accepting of whatever verdict may be reached in this case is for the public to have the ability to see the evidence. So I'm not saying no, I'm just saying you're going to have to really convince me.
Thank you.
All right, any questions about either the seating or broadcasting besides what we've talked about?
No, sir.
All right, let's move to then opening statements. Let me start with what you've probably figured out by now. I am not tolerant of argument during opening statement. So if somebody is arguing and there is an objection, it will be sustained. Please don't do it. What I would like you to do is, by about the time that we're meeting again to select jurors, let me know what you estimate the time you need for your opening is. I will then look at that request and give you a time allotment based on consideration of that request. Each side will be given the same amount of time, and then I will hold you to it. In other words, if you tell me it's going to take an hour, I'm not going to tell you you only have 30 minutes, right? But if you tell me you want 5 hours, I might have some questions about that. But if you tell me you need an hour and I give both sides an hour, in about an hour, you're going to hear me say, counsel, you've got 5 minutes left. Use of exhibits or potential exhibits during opening statement. Because exhibits are not pre-admitted, even if stipulated to, there has to be an agreement to show the exhibit during the opening. Hopefully you both work together knowing what is coming in and isn't coming in, particularly where there's an agreement that something's coming in, other than spite, there's no good reason to not agree to it because the shoe will be on the other foot, so to speak, down the road. So courteous typically pays off with reciprocal courtesy. So work together on that. But technically, if it's not admitted, which nothing is by the time of opening, and there's an objection to using it, I would likely sustain it. For that reason, it's important that you, if you're going to use, for example, like a PowerPoint or something like that, that you share that with the other side at least 72 hours in advance so that they have a chance to review it and then work out any concerns they have and lodge any objections that can't be worked out with me, 48 hours in advance, so that I can then look at it and make a determination. If I haven't given you a ruling by that time and you're coming into openings without yet having a ruling, I suggest you have more than one version ready to go. One that is anticipates the objection being overruled and one that anticipates it being sustained. Let me reiterate again, please do not argue during opening statements or in voir dire, I should mention as well. Make a request at the beginning of your opening to enter the well and it will be granted. However, an invitation and permission to be in the well is not permission to invade the personal space of jurors. So understand that and stay a few feet back, at least from the bar of the jury well. If you are going to use a PowerPoint or some other presentation, you need to choose at the beginning of your presentation whether you want the lights on or off, and they will remain that way throughout your opening, rather than turning them on and off again. So I suggest you do a dry run based on what the light looks like at that time to see what that looks like, to see if you want it on or off. Any questions about openings? All right. Next, I have witnesses. Before we do that, let's take a break. We'll take 10 minutes and I'll be back. All right?
All rise.
I got switched to my headset, guys. There we go. Can you guys hear me okay? Hey, Firefly, thanks for joining. Yeah, just going through the basic trial prep stuff there. Um, what each side expects, what the judge expects. He's running a tight ship, y'all. I'm here for it. I'll have to let me pull this up on the side so I can keep an eye on it. They got 10 minutes, okay. Oh, I'm just starting to get hungry for some reason. Well, probably because I've been up for a really long time. Okay. He did say a couple of interesting things that I thought were interesting. He's very on top of it, Firefly, because like I had expressed before, this courthouse knows what they're doing. He worked a lot with Judge Boyd back in the Vallow Daybell stuff. I've read articles about it. I've done a little research on it about it. Like when he first got moved to Ada County, I went in heavy and started looking at the judge. And so I know how closely he worked with Boyd in the past. And they're working together again now. And some of the methods they came up with to deal with the Daybell trials, they're employing here again in this case. So they're going to run a tight ship. And don't call it the dollhouse no more. Thank you, because we're not children and it's not a dollhouse. And it's very insulting. Like Rachel, I agree. That was a very insulting term to call that, considering what all happened inside that home. I just feel like some of this stuff is so silly at some point. But they're going to, Anne wanting to know where you're going to store it. Don't leave it in the courtroom. The judge is like, I don't want it in the courtroom. You don't want that distraction sitting there when it's not being used, right? So they're going to have to move it to the side and put it outside the courtroom when it's not in use. Those instructions on that touch DNA, my goodness. He's like, I'm not going against science and what their term is, but I'll explain to the jury it doesn't mean it was a direct touch contact, right? Basically was what he was saying. You can't go changing the terms that have been used in the DNA world forever because Anne doesn't like the implication. You got to explain it to the jurors. They're not going to be, they're not jurors that you can't educate, right? Yeah, but Boyce did have some experience behind him before he got the Daybell case, right? But they learned a lot. They really, because Hippler's like I think he's even over Judge Boyce, right? So they worked together in conjunction a lot, trying to figure all this out back when they did the Daybell stuff, because it got big. So he wants he extended the deadline for the proffer on the alternative suspects for the defense, and they're going to have a hearing about that. Now, he didn't say it was going to be closed, though. He didn't specify that, but they will be having some closed hearings coming up when they discuss their jury instructions and stuff like that. Made some rules about jury selection that was discussed as well. Families can be present for that if they want to be, all that. And it looks like if you want to try to get in that courthouse, you know what? I've been on a computer before. I think a lot of you may have, trying to get concert tickets or different things. I'm not like, whoa, that's what if you're all excited, you're pumped, you want to go, and you get on your computer and you don't get in. And then what are you going to do? Make a plan, pivot. Yeah, that's right. The jury has to decide a lot of this, and the jurors aren't, uneducated. They're not in we don't live in a world where you can't explain things to people. I mean, if we live in that world, I'm scared. I'm ready to check out of it because I can't. It's logical stuff. So he's making some very good decisions. I like the way he's telling them, get your PowerPoints ready, get your tiny desk guy ready, get your IT support going. Don't come in here with you don't know how to do this and we can't get this to work, can't get that to work. I'm loving that he's getting all that done now and not just if it comes up at trial, we'll handle it. Because look what that's doing to Karen Reed. How many sidebars a day do we have? How many as it comes up, we discuss it. Situations are we dealing with over there? And it's frustrating. And he expressed that it's frustrating for the jurors, right, to be sent out and have to sit and chill while they're doing what they do in the courtroom. Like a lot of that, that's what I keep a lot. I couldn't believe some of the stuff I was seeing over in Karen Reed's trial happening. Like, why was not all of this hashed out pre-trial? That's literally what pre-trial stuff's for. It just made no sense. Let's just take it as it goes. That's not how you get to court. That's not how you get it done, is it? And this darn things is scheduled to last 3 months, guys. I don't know. Do I have it in me to be here every day for 3 solid months? Yeah, I do. But gosh, that's going to be a long one if it goes that long. Um, oh, I know. 20 jurors. What did he say? He wanted 8 alternate, or no. Yeah, 8 alternates to have a maximum of 20 jurors. That way, if they start to fall by the wayside, somebody makes a mistake, somebody has to get removed from the jurors. They already got it worked out. We got plenty of you extras to go, right? Yeah, well, Bev is a whole different breed. These women judges, like her and Gull, make a lot of women judges look bad right now. So I can't even just tell y'all what them ladies is doing, but they're not doing it right. I can tell you that much. So everybody can blame the judge over there for Karen Reed taking forever, and them jurors want to get mad. They can just get mad at her, Rach. Like she wouldn't put her foot down and get jiggy with it. I think he's doing a really good job at this hearing. Like he's such a no nonsense guy. He's like, I'm here for it if y'all want to, but let's get all this ironed out of the way and get on with the program, because it really has taken a long time to get this case to trial. Yeah, he was going to go with 6, and then he changed his mind to do 8 after. Oh, you know what, Rachel? He said after Friday, didn't he? This judge knows all about the Dateline episode. Damn, Rachel, when you put it into words like that, and I looked at it, I was like, wait, he did say after Friday. He said before Friday, I was going to go with 6 alternates. Then after Friday, I decided 8. Man. He's aware that could affect the jury pool. He's not stupid. But not everybody watches Dateline or the news or anything like that, So he's not a fan of big surprises either. He wants notice of any issues so he can address them now and not at trial. Meaning if you bring this up at trial, when you've had plenty of time to bring it up, I'm going to say no. Objection, overruled, keep going. Yeah, he did say that, Rachel. I didn't catch that when he said it, but because I was thinking, what happened Friday? I'm like, I was so caught up in what he was saying, I didn't think about it like that. What made him change his mind after Friday? Like, duh. The alternate perp stuff, he wants it all sealed. He needs additional information, evidence due to support the allegations. And also, she has to say how it's admissible, because he said that what she had submitted to him so far was almost inadmissible. And I was like, what? Ann, you got to do better. Why do you want to send him something that may not be admissible because there's lack of evidence to support your theory? That would be the only reason. They're not playing around with that court security. That one guy that I know that's sitting way back there on that bench in the corner by the wall, that security guard walked right back there and was looking. I was like, what in the world is that security guy looking at? What are you doing back there, guy? He wasn't doing anything that I could see. Also, that caught my eye or my ear, he said that of course, we heard him say there were going to be 4 family members there right now for Kohberger's family. But he wants reserved seats for the surviving roommates. And he's not happy with the way media has treated these roommates. And I can't say I disagree with him, because I've literally sat and watched people tear these girls down for being 19 and drunk, but giving grown-ups in another case a pretty much free pass for being a grown-up and drunk. And I'm like, I don't understand that. So I'm just, of course, we all had questions and we discussed it. Then it's over. I'm done with it. I can't discuss that forever and ever and ever and ever. I drive my own self crazy. But he's took notice of it and he's made comments about it. He probably like to come out and say a thing or two to media and social media. Could you just hear us all getting a scolding from Judge Hippler? And he brought the media and social media aspect up a few minutes ago when he was discussing all of this. He's well aware of it all. And I think that's the best way to be as a judge, is to be super well aware of it and learn how to deal with it going forward. Put your foot down, make your rules, and get on with it. I don't think she does, Rachel. Well, you know what? There was a name she named in one of her past documents. She named a name. We do know that they did investigate somebody and that they surreptitiously got their cigarette butt to get their DNA. We know that is in court documents. But I'm assuming the DNA from the cigarette butt didn't match what was on that sheath. I don't know why they suspected the person, what was behind the theory on that. I have no clue, but it was looked at. And then you got the 2 blood stains from within the home that were never tested, right? Is she going to try to say that's your third party defense? But like the judge said, what she submitted was almost inadmissible. So that made me think, was it some of the 2 of the blood samples that she was talking about? Because if those were old samples or weren't even enough to put into CODIS and different things, there's a lot of things that go behind all that. And the judge touched on that during one of the hearings. I think it was the April 9th hearing or the one before. I think it was April 9th because that was the marathon hearing. But yeah, she's got to have that. We weren't allowed that third-party defense brought into Delphi because there has to be a nexus. And according to the judge, there wasn't one. Many people disagreed with her, but it's her call in the end. And she said no nexus, meaning no ties, right? Nothing. Or they've been looked into and were cleared, all those things. So I don't know who she's deciding is her alternate perpetrators. Is it only because you found 2 unexplained blood samples in the home, or is it because of the cigarette butt guy, as I call him, or what was it? Yeah, I mean, questioning, in the beginning, Rachel, what happened with that 8-hour gap, and that's normal to ask these questions, and then speculation was crazy for a long time over these roommates. I never thought they were ever involved, in the beginning of this case. None of that ever looked panned out for me, let's put it that way. And then as these documents came out and you realize what all these girls were and were not doing and what they were seeing and hearing, of course it leaves questions, but not to the point where I'm going to tear these girls down and make them look like a villain when the villain is possibly sitting in that courtroom, right? I got to just chalk them up to Karen and her crew over there in Canton, all just a bunch of drunk people. And we're, as adults, seem to be okay with that. So why are we not okay with some 19-year-old girls doing it? Yeah, they saw a lot of stuff and heard a lot of stuff, but like you said, we weren't there. And I don't think I would take too kindly to anybody coming and trying to rip a new one into my 19-year-old under any circumstance. I'll deal with it myself, and y'all just need to back off, is what I tell them. And Ann hasn't brought up any more new filings about that possible cleanup she tried to sneak out into the world. Like Friday filing J, many moons ago, about a year ago, he talked about planted knife sheaths and stuff. That was never discussed again. But there it was, all up in a defense document for the YouTube streets to run wild with. Sometimes there's a lot of weight behind what defense attorneys say, and we should pay attention. And sometimes there's not. right? We have to remember that. Just like prosecutors, sometimes they seem full of it, sometimes they're spot on. It's a case by case situation. And there's just as many people out there that love this judge and like him. There's just as many who are going to say horrible, hateful things about him. I don't think he really cares because he knows it doesn't matter. I keep refreshing it, guys. They're not back yet. They need to fix that court feed, though, before we get on. He's getting on the defense and, prosecution about their tech people. I'm like, well, Judge, you kind of went down a couple of times there. Maybe y'all might need a tech guy, too. Maybe. Anybody available? Go help him out. What y'all think? Okay, let me get that down. All right. I wonder what those 2 hearings in July will be about, though. I need to let me go check the docket really quick while they're on a break just to see if anything's dropped since they've been sitting there. No, just the ones we went over this morning. Only thing there is the ones that we looked at this morning. And that house room decorum, Judge, that was filed yesterday. Yesterday. Guys, we have a pot roast in the crock pot and it's starting to really smell good and it's driving me crazy. I'm like, I might have to get into that before my kid ever gets home. He's the one that put it on. Carol, I know you didn't miss a whole lot. They're just, going through. This judge is not playing, girl. He is running a tight ship and we're here for it. Get all this done before we get out there. And he also talked about how the stream would be controlled, just like they've done in the past cases there. And so I kept telling everybody that use that fixed camera. You're not going to be able to zoom in. None of that nonsense going on. No legs shaking to be observed, and none of that. Just don't do it. We did that in the Gannon Stalk case. Was like that. The judge had control over that camera. The courtroom did. It stayed fixed. There was no zooming. There was none of that moving around the courtroom. We don't need all that extra drama because it's an event. And then what's the prosecution, sir? You wanted certain witnesses' testimony not to be aired, and it wasn't to do with undercover cops. It was your witnesses. I don't agree with that because you don't got to show their face. I get it if they're minors, all the things, undercover agents, but your regular witnesses, you don't get to come in here and say, well, we don't want certain witnesses' stuff broadcast. And then that leaves the door open for the defense over there. Well, we don't want the entire thing broadcast. And the judge is like, I'm not ready to give either one of y'all this because the public has a right to the fair trial, to access the trial as well. Yeah, the defendant has full rights to a fair trial, but we as the public also have a right to see the trial. We didn't have that option in Delphi, unfortunately. And it created the biggest mess you've ever seen in your life. And if you don't follow Delphi, you have no clue, but it's horrendous, right? It caused so many problems that are still ongoing to this day. And the reason why I won't touch that case with a 10-foot pole right now. But I don't want the same thing to happen there to happen here. Because that's not fair to the victims in the end. It's just, ugh. So I'm glad that he told them that, I'm not ready to, you got to really convince me, he said, that we don't air this or not air some of the victims or witnesses' testimony. Don't even start that mess. Carol's got a busy morning. Dolphin's still over there getting her hair done, I guess. I hope she didn't fall asleep on that lady. Rachel, it's out of control, honey. It's simply out of control. There's some unhinged things going on out there. that I don't want any part of. Rick Allen ever gets the appeals process going and something comes down the pike, we might talk about it at that point. Until then, we're done. I want to go back and review that Karen Reed in a little while, though. I got to figure out what this damn medical examiner is going to say. Heard bits and pieces of her stuff from before, but I just didn't want to listen to it yet. I want to listen to it all now in its entirety. So I got to go do that in a little while. Are you on lunch break, Firefly, or you just got an earbud in? You're sneaking. You're sneaking around today. Dolphin went to get her hair done and was going to take her earbuds, and she forgot them. Last time we heard from her, I think she was under the hair dryer about to fall asleep. Bless her heart. And knowing her, she was probably up all night. The judge also made it clear he wants the number of seats they need available so he can accommodate that. And then that's when Ann stood up and said, well, what if we have a couple of defendants' family members come in or fly in? And he's like, well, you just, we'll try to accommodate, but we can't guarantee it, basically. But he told her, he gave her the room to let me know. Yeah, Firefly, the opening testimony actually today, they started back off with Maureen, the CSI lady, whatever she was. Finished off with her this morning finally because I was so over her testimony. It's like I already know that all the bad things happen with that evidence collection, right? But they had to get some things out of her. They got done with her and put the Emmy on the stand. Yeah, I was watching it right before I went live, so I'm gonna have to go back. I did get the Law and Crimes feed into the playlist for you guys, though. If we have time, I don't know. I might come back on tonight and review that with you guys. I don't know yet. It depends on how I feel later. I wonder how long that medical examiner will testify today. You know what I mean? It might be a whole day for her because I don't know what all she's got to tell me. I was hearing her describe the wounds, to John again, and we're getting more in depth about what was and wasn't with him. So it's super important testimony for sure. I had a feeling they'd call somebody on today that we really wanted to hear from that, while we were here. But, what are we going to do? We'll just become great multitaskers, guys. We can get it all done in a day. There's plenty of time. Maybe. Oh, goodness. I think I'm going to have to go to the kitchen and get myself a cold drink. I think I need a tea. In fact, if this hearing wraps up before Karen's trial ends today, I may come live and broadcast the rest of that. We'll see. I don't have anything else going on today. Like I said, dinner's in the crock pot, house is clean, my animals are done. I ain't got nothing else to do. Well, I could find things to do maybe, but maybe I don't want to. Okay, we're still waiting on them to come back into the courtroom, guys. I'll pull the screen back up so we can make sure we keep an eye on it. I just refreshed it again. Oh, let me do this. Oops, come here. Okay, I do have it there. All right, let me do this and refresh, and then I'll bring the screen up because they should be coming back in a few minutes. maybe they'll drop some documents and we'll know what the hearings in July are scheduled for, or they're already scheduled, but what those hearings will pertain to, we'll see. Unless he put them on the docket as a just in case, but I don't think so. All right, and I'll keep hitting refresh to make sure it's when I do it, it goes back to tiny frame. Their headline just says soon. Brian Koberger final pretrial hearing continues soon. Rachel, did you see that thing I sent you guys about the AI they did for the opening statements in the P. Diddy case? That's wild. Have you guys been following the P. Diddy stuff? Any of you besides me and Rachel and Butterfly? Oh, Lordy. Those poor jurors. They're seeing and hearing things they never wanted to see and hear before. I heard things I didn't think I wanted to hear. And I'm like, ooh. Then the judge came out and said those videos they have to watch are now public record. And they need to figure out how to blur out some of that stuff before it gets released to the public. I was like, holy cow. Oh yeah, they went over all kinds of jury related stuff. Hashing it all out. Here we go. He went mute. What happened to you, Judge? We don't have no sound, sir.
Moving on to witnesses. By 5 o'clock each day, you need to give notice to the other side, the witnesses that you will be calling that next day. If it's over a weekend, by noon on Saturday. The list should be a realistic one and not everybody on your witness list. And it should be tiered into two. One is the ones that you definitely are going to be getting to. And then if you have time left over, who you would take and in what order. I do like to use the time efficiently, so I don't generally grant the request if we're normally stopping at 3:30, at 3:10 or so to say, when you end a witness, well, can we just stop here? The answer is generally no. Let's use the 15, 20 minutes that we have, because in a 3-month trial, that adds up at the end of the day. So have enough witnesses ready to go to fill the time. And it's always good to have one or two who you always have at your side. So for example, if the state, a law enforcement officer, who's there, for example, you can call and put on something if worse comes to worse. But I want to make sure we use that time efficiently.
None of that Bev stuff.
With, in addition to giving the list of witnesses you're going to call, you need to provide a list of exhibits you intend to introduce with that witness, short of obviously impeachment, so that the other side can look at those. That doesn't include exhibits that you would put in as part of redirect examination. So for example, the defense in the state's case cross-examines on some other exhibits that you didn't bring up, or there are exhibits that you didn't bring up that would explain what the defense brought up. You don't have to give notice of those exhibits. You don't have to anticipate that, in other words. Now, this is not a remedy or a right that I'm likely is going to be resulting in exclusion of evidence. It is something that you're going to have to deal with me if you're not complying with it. And I will figure out something to make sure that you do, although I don't expect it will be a problem. You should know what exhibits you're going to use, and there's no real secret here about what exhibits go with what witnesses. And I say that because there's always going to be leeway where you have an exhibit that you forgot you need to use, or a witness testifies in a way that you now need to use another exhibit. So, there's leeway there, but giving the other side a general idea of the key exhibits that will be used so that they can review those to prepare, I think is fair. The corollary to my use all the time that we have is don't filibuster. I will give an example that I have used, that I have violated my own rule in the past. When I was in your shoes, where I had a young associate handling a witness who, the next witness was going to be the client, and we didn't want to get to him that day, and he kept turning around thinking he was done, and I kept going like this, meaning fill up the time. Don't do that. Use the time efficiently, but don't filibuster. I've learned to come, as a judge, you sometimes feel like your client is the jury in some ways, right? You want to make sure that that they are comfortable. You want to make sure they are treated with respect, and make sure that things go as quickly as possible for them. And so I've come to respect that. And so I tend to want to make that happen as much as possible. So, don't waste their time, either by having gaps that we can't fill or by filling it with stuff we don't need to use where we could be going to another witness. The lawyer handling a witness, if that is the lawyer handling on direct or the lawyer handling on cross, is the lawyer authorized to speak on the issues related to that witness's testimony at the time it is being offered? And so that is the only lawyer that's authorized to speak about that witness. So if there is a sidebar, only the lawyers handling the witness need approach, if it's specific to that. If it's more general and I need to talk to more of you, I'll let you know that. But I don't want the whole caravan up here for those discussions. Likewise, please do not stretch the shirt sleeve of the lawyer who is handling it by the other lawyer constantly pulling on their sleeve and writing a note and saying, don't say it, they'll get it, just let them do their job.
Amen, brother. You need to call Bev and talk to her.
I'm assuming that there is, based on our prior motions, agreement, I'm assuming at least one of you would like to exclude witnesses pursuant to 615. Because if that's the case, then they will be excluded, generally speaking.
It was the state's expectation that that's what would occur, and that's why we raised with the court earlier on the specific individuals that we've agreed could stay even if they haven't testified yet.
So 615 is one of those rules where if one side requests it, it's granted as a general matter. And so I'm assuming that we're going to be using 615 to exclude witnesses except those excluded by or excused from it by the court. Or you can agree not to use 615.
I want to talk about experts, though.
Right.
Experts being allowed to view other expert testimony.
Correct. Experts are generally excused from 615 because part of what they rely upon is the testimony of other experts. Part of what they rebut is the testimony of other experts. So experts generally are excluded excluded. The parties, or in the state's case, a designated party representative, such as a lead investigator, is typically excused from it. I've already talked about the defendant's family in another ruling, and crime victims are excluded from it.
I want some further clarification with our experts.
And I
know that-
think you guys agreed that your investigators would be excluded from it as well.
We did make that agreement. I think that may have even been in writing.
Yeah. I'm sorry, I didn't mean to interrupt. I just had that thought, and I didn't want to lose it.
So that's okay. I know the court has talked before about the live streaming and being mindful that witnesses not watch the trial when they're outside of the courtroom, just like they couldn't inside of the courtroom. What I want to know is, with experts who are allowed to be in the courtroom, can those that are far away watch the live stream version if they can't make it to Idaho?
Mr. Thompson? Do you have any objection to that?
No, that seems to make sense, Your Honor. And I understood that the court was going to get an admonishment, acknowledgement from witnesses as they appeared.
Bailiff, could you provide one of these to each side, please? This is an affidavit that each witness will have to sign, and you hand to me as they are going to the stand when you're called by them, specifically declaring that they have not watched the live stream. This is for witnesses who are excluded or otherwise consumed media about the testimony or evidence presented during the trial. That's not the, I'm not wed to the exact wording, so if you have wording suggestions, I certainly will listen to them, but that is the gist, is that they will provide such an affidavit each as they come to testify. Any concern with that?
Not with the wording at the moment. A question of clarification, though. If the case should reach a phase 2, does this admonition apply to those potential witnesses for phase 2?
So a witness who is only a phase 2 witness,
Only a phase 2, yeah.
and they attend phase 1, is that what you're asking?
If they watch or attend any part of phase 1.
Well, the problem with that is that phase 1 is also part of the state's phase 2 evidence, as is the defense's, right?
And I think that would support the need for them to be able to know it if the state's going to rely on things that were
Are you talking about experts?
experts and possibly lay people too.
Oh, explain to me why lay people should be excluded from it.
I don't think they should be excluded.
So you think they should not be permitted to watch the trial?
I think I've got some double negatives going on. I think that if we get to a phase 2, I don't think that those witnesses have to be excluded from paying attention to phase 1. I think the protection for phase 1 is separate than phase 2 because of the rules of evidence that apply to any phase 2, the lack of them that apply to phase 2, and because the state's going to rely on what was in phase 1. So yes, experts, and some potential lay witnesses as well.
Mr. Thompson or whoever wants to address this?
Our initial inclination is to leave that to the court's discretion. I think the whole purpose is to avoid prospective witnesses altering their testimony in some fashion based on what they've seen going on in court. That's the danger. I don't know why phase 2 witnesses should be treated any differently than phase 1 witnesses.
Well, what I'm going to do is, I'll give you a chance to each submit something within 7 days in writing on that, and I'll look at it so that you can give me any authority that you might come across related to that issue. Give me a chance to think about it further, and for the two of you to perhaps talk to see if you can understand specifically who you might be thinking of to see if the state has a problem with that. counsel who calls a witness unless it's clearly an adverse witness, in which case counsel needs to notify opposing counsel that they have not admonished that witness. But otherwise, counsel is responsible for ensuring witnesses are aware of orders in limine, otherwise clearly off a testimony that is off limits. Make sure they understand, the Rule 615 requirements and the fact that they're going to have to sign an affidavit subject to the penalties of perjury that they have not watched this stuff. So it's your responsibility to make sure that they're aware, because when they don't comply, I'm going to be asking, why did you make them aware? I'm going to, while we were talking about the jury, I failed to give you the juror affirmation that will have to be signed by the jurors each day. Let me give you a copy of that along the same lines. So that is an affidavit each juror will fill out daily, indicating that they have not violated the court's instruction or otherwise been exposed to testimony or information about the case outside of the trial itself. If I exclude evidence and you need to make an offer of proof, the opportunity to do that generally is when the jury, when we're not working with the jury, such as the morning session or the afternoon session, so that you can make that record as best as possible. That can be done typically by simply making an oral reference to what the witness would have testified or what the evidence would have shown had it been admitted. Okay, I think the rules are pretty clear, but some judges may have more leeway than others about objections. Let me explain to you what my expectations are regarding objections. So objections to questions or exhibits should be stated simply and without argument. It should not be a speaking objection. So for example, an objection, a proper objection might be, for example, objection hearsay. Objection foundation requires a little more. As you're probably aware, there's case law that is an insufficient objection. You have to identify what is missing from the foundation as part of your objection. If you think that doing so would put information in front of the jury that you're not certain I'm going to allow, please ask to approach. I tend to be a rather quick on rulings, on objections. I've been known to, testimony objection overruled, sustained immediately, without even giving you much of a chance to express your concern greater, because I can usually anticipate what the potential issue is and whether or not it's an issue. That said, if you think your ox has been gored and you need to address the issue more, either to have a record or in order to perhaps convince me that I'm maybe looking at it differently than what you anticipated or than I should, please just ask to approach, and then we can have a discussion here at the bench about that. If you need to make a further record for any reason on an objection or in response to an objection, simply ask to approach and we will have that discussion. I'm sure by the end of the trial, we'll have to replace the carpet from the trail leading from council to the bench, but that's fine. As I've shown you before, the court reporter will have a device like this that will allow her to hear through her earphones what we're saying. There will be white noise that's played in the courtroom so the jury and others cannot hear what we're talking about. There will be a physical barrier that blocks most of the view of the jury from what we're talking about at the bench that's rolled out so that they can't see. And we can have fairly fulsome whispered discussions here at the bench about that, whatever the issue may be. I have found in, doing this for far longer than I care to remember, that when I send the jury away to hear argument on an objection, what might take 3 minutes to have the argument on takes 12 to 15 minutes to get the jury back again. And then we lose a lot of time throughout the day that way. And so my preference is, as much as possible, to have those discussions here at the bench. Now, if it's a very significant issue that requires much more leg room, so to speak, to talk about it, then I will chase them out of the room, but I prefer not to handle the more routine stuff. One of the things about, I've had counsel before who confuse the idea of the need to make a record with the need to get my ruling and then offer a rebuttal to it. That is not making a record, that is making a rebuttal. And at least until it goes over to State Street, I get the last word, and not you. And so I don't generally afford that opportunity. So if after I rule and you tell me you need to make a record, it truly needs to be a record on something that for some reason you were unable to make when you had the opportunity to do so, and not simply to see what my ruling is and then try to pick it apart. I will reiterate what I started with, is I don't like surprises. If you anticipate an objection or you anticipate objecting to testimony you certainly know is coming, let's talk it over before the witness hits the stand, before the jury's in the box, so that I have as much time as possible to be prepared so I can give you as best a ruling as I can, and so that you can make as best an argument as you can. If you anticipate the potential impeachment of a witness by prior testimony, whether that's grand jury testimony, whether that is transcribed witness interviews, whatever it might be, please get that to me before the witness hits the stand, and preferably towards the start of the trial, so that I have that available so I can have read it before the witness testifies, so that when you then ask to either impeach or to refresh recollection or whatever it might be, I will have read that testimony. Don't be mistaken in your belief that I have all that testimony. If it, for example, happened with Judge, I don't necessarily have all those transcripts, so get them to me. Or if I do, they're in one of 100 boxes somewhere back there.
Your Honor, if they've been supplied with exhibits and the purpose was just for that, will that be enough for the court, or should I have an extra transcript at the start of the day if I think I need it on paper for it?
So let me know as far as advance as possible, and I will have staff look for that. But otherwise, it's probably safest just to provide me an actual copy of it.
Thank you.
While I'm thinking of it, because I'm in my mind envisioning the materials from grand jury that we have here, the state did file a motion to get back its exhibits for use at trial. I assume there's no objection to that?
Correct.
No objections.
All right. Mr. Thompson, if you may make arrangements with staff here to get those while you're here, okay?
Yes, sir.
And I assume you have replacements you have or will get to me for those?
And actually, we had a procedural question we were going to ask the clerk. I'll ask Your Honor.
Clerk probably knows better than I do, but I'll go ahead and try.
We can do one of two things. We can either get together a set of photographs or copies of the exhibits and exchange those for the exhibits, or take the exhibits, document them, and then give the clerk what we've documented. We're happy to do it either way.
Well, my only fear is that you take the exhibit and then I don't know what the record is of what it actually looked like. Not to suggest that you would be involved in any chicanery and switching something out, but just trying as best I can to preserve that record.
Understood. So we probably will not pick them
Okay.
up on this trip, but we will make arrangements to have that done certainly well before trial.
Very well.
Thank you, sir.
Speaking of chicanery, I'm not fond, and you folks know that by now, of making accusations against opposing counsel that are not well-founded and supported by specific actual evidence. I know that you can get along, but I also know that over the course of a trial, particularly a long one, tension rises. And so I remind you of that to be professional. Don't talk to each other directly when we're in court, right? When the session's going, everything goes through the court as you know, the protocol with courts generally is. Refer to each other by professionally, Ms. Taylor, Mr. Thompson, not by first name, while we're on the record. Again, avoid making accusations that you don't have the tickets for, or the receipts for, I should say. And under no circumstances should you make such accusations in front of the jury. It's a long trial, so as much as I want you to be prepared, and a witness who's flown in that needs to get out again at the end of the day. And so it may be that we need to stop one witness's testimony to get the other witness in and then pick the other one up. As long as there's no clear prejudice from that, I'm generally flexible in allowing that so that we can accommodate that. And I ask you to both be accommodating to each other in that regard. All right, any questions about witnesses' testimony?
Just one, it's kind of a takeoff of what the court just mentioned. We have at least one, maybe a couple law enforcement witnesses in particular who have testimony relevant to different stages of the case. And it's our intent, with the court's permission, to call them at different times instead of trying to figure out how to call them once and have them talk about what's going on at this stage of the case and then what may be happening next week with the case. Is that acceptable to the court?
Well, let's start with whether it's acceptable with Ms. Taylor.
Your Honor, I don't know that I have a strong objection or really any business in telling the state how to put on their case. That feels really cumbersome to me. I was hoping for leeway the other way when we would call a witness ourselves, but they're a state's witness. I'd hope to have a little leeway to do all of my examinations so they didn't have to come back. I would otherwise defer to the court.
Certainly, if you're, somebody's on your witness list, if you want to go beyond the scope of direct as part of effectively your case in chief in advance, I don't have a problem with that. And so if it's going to save bringing another witness back, I don't have a problem with that. I don't have a problem if it doesn't get too cumbersome.
Yes, sir.
If we're having a law enforcement talk about a broad area of one phase of the investigation at a time, that's probably okay. But, having them come up and narrate between every other witness is probably too much. Then the question becomes is how do we handle cross-examination? And basically, I will defer to the defense on that or the other side on that to the extent that we allow, which is, do you want to cross-examine about the information they just presented now? Or do you want to wait until their last presentation and cross-examine about everything? And so that'll be up to you.
Your Honor, with that said, then I guess I'd request that the state let us know when they call a law enforcement that's for a limited purpose right now, but is coming back for another purpose.
Yeah, they need to let me know that as well.
Yes, Your Honor.
And if you don't let them know that, and, well, either way, it's your responsibility to ensure that they're back at some point available to the defense so that they can cross-examine, even if you decide, oh, I don't need them anymore. You better not send them on an airplane somewhere where they're unattainable. Because the remedy may be to strike all of their testimony as a starting point.
We would anticipate asking court and counsel if this witness may be excused if we're finished with them. And then that would give Ms. Taylor or other counsel an opportunity to let us know whether they still need that person.
Okay. Likewise, when you look at each other's witness lists, talk with each other and then write it in, get it in writing so we have it as to whether or not, for example, Ms. Taylor will need subpoenas to witnesses you have on your list that they want to also call, or if the other way around, you need subpoenas for their witnesses, or whether they will essentially agree to make them available. Anything else with respect to witnesses before I move to exhibits?
No, sir.
Okay. All right. So I did require a meet and confer for you to go over exhibits, and I got those, and I appreciate the start that you have on those. There are a number of exhibits where there's, appears to be, I can't tell. So for example, there's an objection to, for example, relevance or hearsay. Part of what I wanted to know, though, to start is, regardless of whether it's ultimately admissible for those reasons, is there an objection to authenticity? In other words, I want to make the trial go as quickly as possible, avoid the need to put on a bunch of witnesses simply to say, this is what this is, and they don't really have any substantive discussion about it. They're just authenticating a document that, if we were to be honest, there's no dispute that it is what it is. And so I may have you go back and look at that and add another column to the list, which is objections to authenticity. Some of the stuff, key actual evidence items, whether that's DNA or whatever it might be, obviously the defense is entitled to put the state to its burden with respect to chain of custody and all that, so I don't expect that. But on some of the other stuff, certainly to the extent that we can agree that if there's no good faith basis to contest the authenticity, then let's try to do that for everyone's sake. In that vein, I know the state had to withdraw its request to have certain documents self-authenticated to go back and do more work. Where are we at on that?
Ms. Jennings can speak to that, Your Honor.
Your Honor, I believe that we've submitted all of the certificates of authentication for all the exhibits we plan to introduce that way.
Okay. And you submitted those to the defense to review?
Yes.
And Ms. Taylor, are you going to respond to those?
Your Honor, we did. We met with the state last week, I believe, or the week before, and we discussed some of those records. There were some issues with them. Ms. Jennings provided me with a thumb drive, and I don't know if those have corrections on them, but I'll continue to let the state know what we think, if we continue with an objection or if we're satisfied that the rule's been met.
Okay. If you could get with each other and then provide me I didn't study the exhibits that I got a day or two ago, or the spreadsheet that closely, but make sure I'm aware specifically of which exhibits there is no objection to the self-authenticating or otherwise not an objection to authenticity. Doesn't sound like we're going to need a hearing on that, at least for the time being, though.
Not that I'm aware of now, but certainly we'll keep our eye on it. I can alert the court, and if we can squeeze it into June 18th, that's possible. Maybe we
Sure.
can start that at noon.
Okay. And then I would certainly caution, at least because the state goes first for now, I'll say the state, that, belts and suspenders are good ideas when it comes to trials. So I would have my people I need to authenticate things under subpoena, just in case. Especially if they're out-of-state witnesses, because that's not something you can do overnight. So the methods of displaying evidence to the jury, generally there's three ways to do that. One is by putting it on the Elmo and projecting the physical document, whether it's a writing or something else. The other is if it's a writing or something else, using litigation software of some kind to project it through the computer. And the third is passing it through the jury. That last one is the one I want to avoid as much as possible because that just takes too much time. So try to use the other two approaches as much as possible. Now, there are going to be some physical objects that it may be important for the jury to see, and I get that. But in general, photographs, things that are in writing.
They're still froze, guys. I'm trying to get it to work. There's two different feeds, and they're froze on both their feeds. I guess they're working on it. There we go.
in the form, just use that exhibit?
It's on them. They
Okay.
keep. There we go. I don't know what the court's doing.
I think my staff explained to you that in terms of submitting exhibits to the court in advance, if you would provide 2 copies of the exhibits in notebooks, so 1 copy in one set of notebooks and 1 copy in the other set of notebooks, and try not to make the notebooks bigger than about 1.5 inches each, at least on the copy you give to me, because it's just too unwieldy to use a 6-inch binder up here, or if I need to take it home and read it overnight to do that. So try to keep it to about 1.5 inches per. And then for the actual exhibits that are going to be admitted, provide those first day of trial or whatever to the clerk in each exhibit in a manila folder with the exhibit number marked on the outside of the folder on the tab, with the sticker attached inside the exhibit, so that she'll have a box of the proposed exhibits, the originals, and you can ask for exhibit X or whatever, and she'll hand it to you to use. At least for the document exhibits and photograph exhibits. Physical object exhibits, work with the marshals on getting them in the courthouse. So for example, if it's something that's going to raise alarms at the security line, such as, I don't know, a knife, make sure you've got the aid of security in advance to get through that. The TCA can direct you to the marshal service and who to talk to there. We tend to use for dangerous items like guns and knives, a display box that the item would then be locked in to display to the jury, and so that can go to the jury without fear of an accident happening. I don't think there are any guns in this case, so I'm not as worried about that in terms of those being pointed at anyone by accident. But in terms of the knife, it'll probably be in a display case. If you're going to be using illustrative exhibits, give counsel notice of that as reasonably far in advance as possible for them to have a chance to look at those. Items for which chain of custody needs to be maintained until it's admitted, I'm going to leave that to the state to figure out where it's going to be stored and how it's going to be stored. Whether that's with a sister agency or whether you're going to have the sheriff up there bring down a trailer that can be locked up and kept at the sheriff's here property or something like that. However you want to do that, I'll let you worry about that. For physical objects, also provide color photographs so that we can have those in the record. At the end of the trial, we will likely give back physical objects to law enforcement to maintain. Depending on what it is, we'll see, and depending on what the outcome of the case is. But it's nice to have those color copies available for the record. Triple check all of your exhibits, particularly documents, audio and video, to ensure that there's nothing on there that is not supposed to be on there. Give audio and video to counsel far enough in advance they have the opportunity to determine whether they have an objection to anything in there, and you have the opportunity to either make redactions in accordance with the objection or to get a ruling from me about those redactions. What I don't want is the jury to be sitting in the back room while you all are making redactions at the last minute during the middle of trial. All right, for closings, kind of the same idea. I'll ask in advance for a time estimate, and then if it's reasonable, agree to it, but then hold you to it. A little bit more liberal, obviously on closing than in opening. If you're going to display things in closing, kind of the same light rule goes, which is lights on or lights off, so you'll have to choose. You can move about the well, but don't get in the juror's personal space. The state, when it gives me a time, I will keep track of that, and then for rebuttal, it'll be whatever you didn't use. So when you're giving me estimates, include your rebuttal in that. If you would like time reminders from the court throughout it, for example, if you're planning to keep 20 minutes for rebuttal, you can ask for a heads up at 30 minutes or something like that when you have 30 minutes left, so just let me know in advance. All right, questions either about closings or about exhibits?
Your Honor, as to the defense exhibits, it would be helpful if they could be separated or at least delineated between which is for the penalty phase and the guilt phase, as the court will see when it looks at our spreadsheet of our responses to the defense exhibits. Some of them, we could see we wouldn't object to them in penalty phase, but we would in guilt phase, and they aren't clearly delineated at this point. If that's something that we could have addressed sooner than not, that would be very helpful.
Any problem with that, Ms. Taylor?
Your Honor, no problem. We did go over that when we met last week, and I identified which ones were for a phase 2 if we get there. I don't have a problem stating so, but we did make them aware.
Okay, well, maybe if you can just put it in writing so that they have it, that'd be helpful. That way we don't have any misunderstanding between the two of you. Thank you. All right, once you get and revise your spreadsheets based upon what we've talked about today, I'll start about part of what I'm going to do with the time that we have between now and trial is start going through all those, looking at what your objections are, getting my preliminary thoughts together on that, and then we may have another hearing just to kind of go over some of that if I had stuff that I think I can rule on in advance for you, or if I have questions, et cetera, but I'll let you know. All right, anything else before I move on to jury instructions?
Not from us, Your Honor, thank you.
As far as objections, Your Honor, the court has issued a number of decisions on motions and limine motions to dismiss. From the defendant's trial brief, the defendant indicates that he plans to raise those same objections again at trial. And it strikes the state that if that's going to happen, to preserve the record for no other reason, that should be done outside the presence of the jury, as opposed to interrupting testimony and the presentation of evidence on matters that have already been ruled on by the court, if that is acceptable to the court and counsel.
So there's not a need to object again if I've already ruled on the objection. If you're asking me to reconsider, yeah, I think that's something you need to take up outside the presence of the jury, if that makes sense.
That does make sense, and on situations that may arise where we might want the court to reconsider, we'll definitely take that up outside the presence of the jury. I do want to make sure that things such as the model house that was the subject of a lot of objection, that there's a noted ongoing objection to it. I don't mind anticipating that and bringing that up before trial starts and outside the presence of the jury.
And to be fair, I only have what was proffered, right? And so I had a general proffer that the testimony will be that it, as I understand it, that it is consistent with the general layout, but not to scale, and that it would be helpful for the testimony. I don't have a problem with an objection based upon what that proffer is actually at the time. And so I think that's fine. I don't think that there's a need for an ongoing objection once that's done, but that helps.
Yes, sir. Thank you.
Jury instructions, I provided to you, I think yesterday, maybe pre-proof instructions. Did you get those?
I did not receive those.
Have we not sent those out? All right, I'll send those out probably today or Monday. They're not particularly, I think, controversial. They're pretty stock. On the pre-proof, in a capital case, there's a instruction. Normally what we instruct the jury is don't concern yourself with punishment, the subject of punishment. In a capital case, we are supposed to instruct them under 700B of the capital instructions in the pre-proof phase that it is a capital case, which obviously they're going to know through jury selection. So there's that instruction in there. And what I've done is we're also supposed to instruct them with 700C, which is this is a capital case and you'll have to decide if you find the defendant guilty, what penalty to impose. But then 700C says, instruct them in a separate instruction, don't concern yourself with the subject of penalty or punishment in the guilt phase. I've combined those two things together, so take a look at that. I think it reads better than trying to do two separate, potentially contradictory instructions. I think that does it in a way that makes it more understandable. Other than that, they're very, very stock instructions. If there are other instructions that the parties want to be included in the pre-approve, for example, any stipulations that they want me to advise the jury of, let me know by submitting a request and copying my law clerk on that as well. I think you'll probably get before too long a set of post-proof instructions that are very loose in the sense that obviously I can't anticipate everything. It is based on what I sort of understand now. But it's helpful to have a discussion about that as early as possible so that we're all singing from the same hymnal in terms of what the likely instructions are going to be. And, for better or worse, as you know, the Supreme Court last year in 2024 revised all their capital instructions. And so in light of that, I will be as much as possible sticking with what they have provided, given that it's clear they've obviously given it recent thought. And so I think that best insulates the case from perceived error by the court is by using instructions they've recently given us. My plan would be, if there is a guilty verdict on any of the counts of murder, would begin the penalty phase as soon thereafter as we can. Certainly probably the next day, unless it's, Friday morning when we get that, then we may not start till Monday or something. But given that the jury will certainly be sequestered during that process, the plan would be to go forward. I also will use as much time as I've told you throughout the day to get that accomplished as we can. If that happens and we are in a penalty phase, and there is a finding of aggravating circumstances where then the court's discretion about which penalty to impose is pretty limited in terms of my discretion. In fact, i.e. none. It's either life without parole or death, right? In that case, I just want to get, before we get to that, defense's position on sentencing for the burglary charge, if they have concerns about sentencing at that time as well, given that it's probably not even a tail wag on the dog, let alone wagging the dog. So, but I'm not going to make you tell me that now, but I will ask you before the jury goes out what you want to do. I'm going to hand you another piece of paper that I would like to get back from the defense sometime in late June or early July, which is a declaration of last best offer. In other words, identifying whether the defendant received an offer and whether he has accepted, rejected, et cetera, just so that for purposes of post-conviction, we've documented that. Okay. Let the court reporter know whether you're going to want routinely daily transcripts or not. You don't have to tell her now, but
Daily versus real time?
so there's two options. You can have none, both, or all, or either. One is I think we can set up real time where you get real time at your table for whatever the charge is from the court reporter for that. Also, there's the potential to get transcripts each day. I don't think those things are mutually exclusive. In other words, you could order both.
There's separate fees if I want both.
Correct.
May I make that decision?
Yes, not now. You may make that as we get close. And just contact the TCA and she will talk with the court reporters that will be assigned to this to make sure you understand what their structure is, or fee structure.
Thank you.
And we obviously need to know particularly about the real time in advance so that we have the technology set up for it. And it may require you to bring some of your own technology in the form of a tablet or a laptop on which it's displayed, right? Because we don't supply the hardware, just the software and the actual reporting. Okay. My plan today, as we sit, is to get through the jury selection. I see where we're at with the intent that we not sequester to start. As I explained this morning, the more people talk to the media and the more things that are in the media that are not admissible, whether true or not, the more difficult it makes things. And so I'm going to have to figure that out as we get close. For now, intent is not to do that, but we will have plans in place to revert to that if we have to at any point during the trial. Do either of you want to make a record about sequestration at this point?
I would say the only record right now is that we understand what the court is saying during jury selection. If we still don't know if that could come up, the potential jurors should just be aware that it could come up prior to
It'll be
these
part of
two.
the question that the questionnaire, as well as part of the hardship determination is there some reason they would be unable, I get that they wouldn't like to be, but would there be unable? Do they have a sick family member they care for or whatever, where they have to be home, right? So we'll talk to them about that. Anything from you, Counsel, Mr. Thompson, about that?
Not at this point. I understand the court might entertain some things in a closed environment later today, and we do have some sensitive issues to raise at that point.
Okay. That's my list of things. Did I miss anything, Giovanna, that you can think of? All right. That's my list of stuff, and I know this has been a very sort of nuts and bolts kind of lawyer discussion today, but that's generally the nature of pretrials when there aren't contested motions to discuss, and so that's my list. I'm happy to answer any questions about my preferences or how I handle things that I haven't talked about, or address anything else that you want to talk about. I know we do need to go to a closed session at some point to talk about what will be asked of the jury specifically. I need to avoid that getting out to potential jurors, so we'll do that in a closed session. But anything else in the public session we need to talk about?
I believe so, Your Honor. Thank you.
Your Honor, thank you.
Okay. Let me just look at my notes real quick before I dismiss the public, and we probably take a lunch break and then come back and take that up. I do have a copy. I told you there's a new administrative order. I'll give you a copy of that just so you don't have to go dig for that. What's that? You've already given it to him? All right, perfect. Thank you.
If there's a spare that we could have, Your Honor, that.
Sure.
Oh, it's already at hand. Thank you.
Actually, I have copies of the preliminary instructions for you.
Oh, thank you, sir.
In the closed session this morning, I indicated to you I am going to be entering an order requiring retention of records by the state, and I'm going to write another one extending that to the defense as it relates to violations of the non-dissemination order. I'm going to give you a copy of what that order is going to look like that I will execute likely over the lunch hour. It does require some action on your part, counsel. And as I indicated, I would be open to a request for a appointment of a special prosecutor, and that special prosecutor to ask for a magistrate inquiry so they have the power of subpoena and the power to question witnesses under oath, as well as the power to grant immunity. So I will be looking for that from you. And that one just deals with the state. I will get you one that deals with
Somebody's
your
in
side
trouble.
to preserve records, all right? All right. Anything else? All right, thank you. Why don't we come back in about an hour, all right?
All right, the rest of that hearing is not going to be held public, but from what he just said, so this morning when they were late starting court, they had a closed session. And they discussed what happened on that Dateline episode, because now he's decided to give the defense a retention of records order like he did the state this morning. And it concerns the non-dissemination order. And what's this immunity stuff? You tell on the person you won't be in trouble. Oh boy, somebody in trouble this morning, but oh well, not our. I'm sorry, I had to move my thing, my big cup out of my way so I could see the screen. Goodness gracious. Yeah, Donnie, a lot of it was standard, protocol stuff. This judge is really hammering it out to get everything ironed out and in order um, before the trial. So, do you guys think they found the knife, or was the judge just saying that as an example? All right, because it's not uncommon to pass a physical piece of evidence to a jury. I've seen it 1,000 times. You like he was talking about displaying the photos up on the big screen. There's no need to hand each of them a copy of a photo. You're literally displaying on a big screen. But the physical piece of evidence is not uncommon for it to go through the juror's hands. But he was saying anything that may can be considered dangerous should be inside of a glass container, plastic container, you know what I mean, little display box. And he used the word knife as an example. So just curious, the wording on that one. Because we know that they did find several knives in Pennsylvania. They gave descriptions of those knives on the search warrant return. But the very first thing on the search warrant return from Pennsylvania, it just says knife. It's literally the first thing listed. There's no description. The other knives found have a detailed description as to what kind they were. That one just says knife. And we're like, oh, well, that's curious. It's not a cutlery knife like one description. It's not a Smith & Wesson pocket knife like the other description. And I can't recall the other one right off the top of my head. That one just says knife. They have a special prosecutor on board to help with some things, but it's a death penalty case. And then whatever went down this morning I got to go back and review that very last part, because that's what he's talking about. That special prosecutor would have come into play with that. They already have the prosecutors from the DA's office appointed, right? They have an assistant now appointed over there as well. So they got 2 DA guys already over there. So, but a special prosecutor would be, I really don't know why they want to appoint that when they already have the other ones. So I've got to go back and review that part, because he said it right after he was talking about this morning's hearing and the non-dissemination order and all that stuff. Because I think Ann's going to use that, right, to the best of her ability. But the judge already is aware that stuff's out there, and they got to screen those jurors for that information. And I like the idea of him giving those affidavits to the witnesses. Sign this and say you haven't watched this stream, right? Or the trial. Because he's trying to preserve the public's right to view these trials without, and at some point you've got to expect adults to be adults. And if you want to be a part of the trial and you want to be a juror, you need to follow the rules and not watch the case. But is everybody going to be as level-headed, right? I don't think, that's a toss-up right there. It's hard to gauge that one. It's insane. Well, they wouldn't really have a reason to show them okay, if I'm the defense attorney, you're not bringing in knives that weren't used in the crime, or you don't feel like my pocket knife, it doesn't need to come into court, right? The cutlery knife, if those weren't used in the attacks, they don't need to come into court. So there's no real reason to bring those other knives in unless they pertain to the crime, or they allege they pertain to the crime. So I think he used that term as an example instead of, because he also brought up gun. Kohberger had a gun too, but he didn't use it in the commission of this crime. And the burglary things keeps being brought up. That's not the first time, and it got brought up a few weeks back, because people were alleging, oh, well, that's, part of the code. Once you break into a home, is considered burglary. I'm like, really? Because there's breaking and entering, then there's burglary in Florida. There's literally breaking and entering, and then we have burglary. So did he take something from that home that they were fully aware of, right? Was there something missing from the home that the other roommates were able to point out, or a family member was, able to specifically point out? I don't know. I wonder if the search in the Lolo Mountains turned up anything when they was up there looking for that knife 2 summers ago, allegedly. I don't know. What do you guys think? So what do you guys, are y'all, it seems like y'all are all impressed with the judge, right? Do you think he did a good job? I think he did a good job. I think he did a good job handling everything, trying to iron out all the issues beforehand because, goodness, that stuff's important, you know? It doesn't make any sense to get in the middle of a trial and then start your objections on stuff you knew was coming in if you can handle it now. That does make the trial progress. And I get where he's coming from. We are looking at a 3-month trial here. I don't want all that chaos I'm seeing over there in Bev's courtroom with all these multiples. And what else? Every time there's a sidebar in Karen Reed's case, every attorney gets up and trots up there. And he's like, no, 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 we're not having that. I don't want all of y'all coming up here for every sidebar. Only the attorney handling the witness on the stand needs to come up here. And he's right. The other attorney can go back and convey the message, especially if he's the one handling the witness. So I feel like he's going to run a tight ship, and we're here for it. You'll be watching the replay. Yeah, I'm about to. We may come back on tonight and discuss a few things between this case and Reed's case. I'm going to go watch the rest of her testimony. Let's see, it's only 1:16. What do you guys want to do? I might come back and put the rest of that. They should be coming back from lunch. Here, let me check their feed. Are they at lunch? What are they doing? Are you guys bouncing back and forth, or some of you watching the Reed trial? You know I don't care. You go do you, boo. We're here for it. I'm not going to scream at people because they wouldn't watch something that different, you know? Everybody follows different stuff. So let's see. Oh, where's my thing? There it is. Almost forgot what day it was, y'all. Okay, they still got the medical examiner on the stand. I want to see her whole testimony, so I might come back in about 30 minutes just to start her at the beginning and play it through. If you guys want to come join me, you know you're more than welcome to. I might go in, and I don't want to go catch in the middle of what she's saying. That'll be confusing to me, so I need to go hear it from the beginning. So I at least want to see her testimony. So I think I'm going to do that. Maybe I'll come back in a few minutes. And Ann was given a little more time, Donnie. She was supposed to have that turned in yesterday. And apparently she turned something in, but the judge said it was almost inadmissible, meaning she didn't back it up. And so he gave her an extension on that to when there's also going to be another hearing packed in here in June. We had 2 added in July. So he gave her to what date? The 23rd, I think. It's alternate perp evidence needs to be, additional info needs to be added and turned back in by the 23rd to support her allegations on how it's admissible, because what she turned over is borderline inadmissible. So that says, you know, how strong is her alternate perp stuff. You can't just walk into court and say, Saudi defense, some other dude did it. You need to tell me why you think some other dude did it. Who is he? The judge wants to know the name, and he wants to know why. So is it because the cigarette butt guy, is she going to point the finger at him, somebody they investigated and ruled out, or is she going to point at the 2 blood stains that went untested in the house? You know, I still don't even know. We know one was on the stairway handrail. We're not sure where the other one was. Yeah, 23rd of May. And they're going to have another hearing scheduled for the 18th. And the judge Ann said she could have materials ready by then for that as well. She stuck that in there on that day because there's something else they're going to hear on the 18th as well. And then Ann said she could provide that by then as well, in case there was a hearing that needed to be held on it, right? That they can take care of that on the 18th hearing of June if there is an issue. So, what was the other thing they said they would bring up at that hearing if need be? Yeah, Ann's got to show a nexus, you know, with her alternate suspects. And Right, Butterfly? We can do that. We can rewind and fast forward through all of it, and we can stop and talk about it at the same time. Ooh, it's something we're not used to doing. Oh, goodness. I tried to stay silent. I was getting the silence was killing me over here in my house. As all I could hear is this court trial. I'm like, I'm not talking. It doesn't seem natural. Yeah, Donnie, 23rd of May is when all that's due. And they're going to have a hearing on the 18th of my grandpa's birthday, June 18th. They're having a hearing. And then we have 2 more scheduled in July, but we don't know what those are for yet. They weren't no information on the docket about what those were actually for. And we heard the judge hand delivering orders there that he didn't think was dropped in the docket yet, but they actually were. And surprisingly enough, like Rachel pointed out, he said up until Friday, he had 6 alternate jurors in his head. He's thinking we'll need 6, but after Friday, he said, oh, we'll need 8. What happened on Friday? Dateline. They're well aware of that Dateline episode. Oh my goodness. Wow. All right, guys. Well, I'm going to take a break. I'll shut down. Let's give it 30 minutes. I'll come back about 2, if that's okay with you guys, and we'll run for a little while for the, I don't like keeping you guys here during the dinner hour and all that. We all have things to do in the evenings. So we'll come back. I'll go to get myself a snack and a drink and all the good things, let my animals out, come back in, and we'll come back up and we'll watch that medical examiner's testimony, because I really want to watch it with you guys and get your take on that as well. So I'll go set that up and get it out there, and I'll see you guys back here in about 30 minutes. And until then, I'll see you later, guys. See you soon, I should say.
Thank you all for watching this here video. Please like and subscribe and follow. Much love from Little Yas to each of you.